So in the previous class, we concluded with the discussion of which topic? Emergency provisions, right? So in emergency provisions, we discussed about 3 types of emergencies. Which are they? National emergency, President's rule, and financial emergency. So which article deals with the national emergency? 352. President's rule. Next, financial emergency, 360. So whether all the 3 emergencies have to be approved by Parliament? Whether all the 3 emergencies which have been proclaimed by the President have to be approved by Parliament? Yes. So once approved, what will be the life of the emergency during national emergency? Yes, 6 months. Life of emergency will be 6 months once approved. Next, President's rule, 6 months. How about financial emergency? No, it is indefinite. Okay, it is indefinite. Now, national emergency can be extended how many times? N number of times it can be extended. Okay, approval is required after every 6 months. Next, President's rule, 3 years, maximum 3 years, and again approval is required for after every 6 months. In case of financial emergency, whether extension of approval is required? No. So in all these 3 cases, who has the power to revoke the emergency? President. Okay. In one of these emergencies, some special body has a power to impose pressure on President. Which is that body? Lok Sabha. Which kind of emergency? National emergency. So among which of the emergencies that we have discussed, there is an impact on fundamental rights? Yes, national emergency. During President's rule and financial emergency, no impact. So during financial emergency, even the salaries of the judges of Supreme Court can be reduced. True or false? They can be reduced. Okay, good. Next, state government will be suspended in case of which emergency? President's rule. In case of national emergency, it continues to exist. During President's rule, state legislature will be suspended. It will be dismissed or it may be dissolved. Okay, dissolved. So here suspended and dismissed, because in different contexts they use different words, both of them mean the same, whether it is dismissed or whether it is suspended. Okay, suspended. So next, similarly, we shall begin with another topic, Supreme Court. Okay, Supreme Court and High Court. So in textbook what they have done is in Lakshmikant, so there are 2 separate topics. One is Supreme Court, another one is High Court. So what I have done is while compiling the notes, so I have made based on comparison. So wherever possible, when we learn through comparison, then it will be easy for us to distinguish the powers between the Supreme Court and High Court. And once we cannot compare, then I will be discussing individually the provisions of Supreme Court and the provisions of High Court. Okay, High Court. So once we complete this topic, we will be completing both the topics, Supreme Court as well as High Court. Okay. So every important point from the book I added here. So you need not go back to Lakshmikant. If you want to go for one reading, you can go for it. Otherwise, this is more than sufficient. Okay, more than sufficient. So Supreme Court history and High Court history. Now again, there will be some data which will appear inconsistent with the things which you have already learnt. Okay. Again, we also need to understand the exam's demand. So wherever there is inconsistency in the data, we will not focus much. Okay, we will just make the progress to the next points. Okay, that is also very equally important. So Supreme Court. Initially, a Federal Court of India was established through Government of India Act 1935. When we go to the history of Supreme Court, a Federal Court of India was established through which act? Government of India Act 1935. Now after completing the discussion of Supreme Court and the High Court and many other things, we will be going to the initial topic called as historical evolution of the Constitution. So in that topic, we will be discussing that Supreme Court was established in 1773. Okay, so there will be confusion. Here we are saying Federal Court of India, there we said in 1773 Supreme Court was established. So no need to compare these things and get confused. So whatever information has been presented here, you just stick to it. When we start discussing about the historical evolution, we will stick to that content. So let us not compare both of them and get confused. Okay, get confused, very important, because majority of the times what happens, we get confused and we will get stuck there itself. We will not be able to make progress. Here very important thing is we have to make progress. Okay, we have to make progress. So Federal Court of India was established through Government of India Act 1935. So now from the exam point of view, if they ask, so which act led to the establishment of Federal Court of India? Government of India Act 1935, 1919 or 1909? You should be able to identify 1935. Next, single system of courts. Government of India Act 1935. So single system of courts means, here we understand it's like an integrated system, but for both central as well as state. So again, it was established through Government of India Act 1935 itself. Next, Supreme Court of India was established on January 28, 1950. So it succeeded whom? It succeeded Federal Court of India. So Federal Court of India was replaced by Supreme Court of India. Federal Court of India was formed as a result of Government of India Act 1935, whereas it was replaced by Supreme Court in 1950. So please retain this information also. They are never asked, but out of curiosity, please retain this information as well. January 28, 1950. So India became a republic on January 26. Okay. 2 days after that, Supreme Court was inaugurated. It was established. Supreme Court jurisdiction. So what do we understand by jurisdiction? The power to resolve the cases. Okay. For example, a court is there, it can solve only murder related cases. It cannot solve, for example, theft related cases. So the jurisdiction of the court is only murder. Okay, murder. So the different category of cases that a court can handle, that is called as jurisdiction. And also jurisdiction also means area. For example, a court can hear, for example, let's assume Karnataka High Court can hear murder related cases only of Karnataka. It cannot hear murder related cases of Maharashtra or Tamil Nadu. So we call that the territorial jurisdiction of Karnataka's High Court is Karnataka only. So in this format, which all cases it can take, that also comes under jurisdiction. Which all cases it can take from which area, that also comes under jurisdiction. So here what we understand here is the jurisdiction of which is wider, Federal Court of India or Supreme Court of India. So Supreme Court of India's jurisdiction is wider than that of Federal Court of India. Now next, don't go to the deeper level. So which are the cases which FCI can handle, which are the cases, extra cases which Supreme Court can handle? Again, not important. Okay, not important. They are not mentioned in the book also, and we will also not explore for more information. Only thing that is important here is whether the jurisdiction of Federal Court of India is more or the Supreme Court is wider. Okay, it is Supreme Court. Okay, it is Supreme Court. Next, replaced British Privy Council as the highest court of appeal. So what do we understand by appeal? Yes. No, what do you understand by appeal? So when you watch a cricket match and all, they go for appeal, right? So what is that appeal? Okay, appeal means when you are not satisfied with the judgment, you will go to the higher court. That is called as an appeal. So now the judgment that has been given by district court, if you are not satisfied, what you will do? You will go for an appeal to high court. If you are not satisfied with the judgment of the high court, you will go for an appeal to Supreme Court. Okay, Supreme Court. In that fashion, replaced British Privy Council as the highest court of appeal. Means previously, before 1950, before the Supreme Court was established, when Federal Court existed, Federal Court of India existed. Now let's assume district court is there. So a person will go to district court, the judgment given by district court, a person is not satisfied. Next he will go to high court. The high court also it will give the decision. Again he is not satisfied. He will go to Federal Court of India. If the decision given by Federal Court of India is also, it does not satisfy him, he will go to another body called as British Privy Council. British Privy Council. Now we will not go into detail like what exactly is British Privy Council. We have to stop here itself. Okay, we have to stop here itself. Because once the Supreme Court was established, now there is no appeal to British Privy Council. So which is the highest court of appeal now? Supreme Court. Because FCI was replaced by Supreme Court. Now if you are not satisfied with the decision of the High Court, you will go to Supreme Court. If you are not satisfied with the decision of the Supreme Court, then what you can do? Then you have to commit suicide. Because there is no other alternative available. Okay, so the highest appeal where you can go is, you can go only to Supreme Court presently. But before that British Privy Council was a what? Next appellate body. Okay, appellate body. We will not go into detail as what is British Privy Council. Okay, Privy Council. Next, High Court. So in 1862, High Courts were established at Calcutta, Bombay and Madras. So again, there are a few other information which has been presented in the book. Again, that information is not important. Only you store this information. So where were the first High Courts established? Okay, in 1862, they were established at Calcutta, Bombay and Madras. Okay, so this is the historical background of High Courts. Okay, High Courts. Next, so how many Supreme Courts are there? Only one. High Courts? Each state one. Generally, okay, each state has one High Court. But through 7th Constitutional Amendment, what they said is, there can be a common high court for 2 or more states and union territories. Okay. Now whether in India how many states we have? Yes, 28. Okay. Whether all the states have their own high courts? No. So Karnataka has its own high court? Yes. Can you give me an example of a high court whose jurisdiction extends to more than one state? Assam. Okay. Around close to about 4 to 5 states. Okay. 4 to 5 states. So can you recall now jurisdiction of Lakshadweep comes under which high court? Kerala High Court. Jurisdiction of Andaman and Nicobar Islands, it comes under Calcutta High Court. Again, we will be discussing in detail. So what we understood here is initially as per the constitution, it was mentioned that each state should have a high court. But later on through 7th amendment, what they brought? They said that 2 or more states or one state and one union territory, so more than one entity can have a common high court. Common high court. From exam point of view, they are not going to ask you frame a question like this. Through which amendment it was mentioned that 2 or more states can have a common high court? 7th, 5th, 6th, 8th. Not important. Here concept is important. What is that? So 2 states can have a common high court. 1 state and 1 union territory can have a common high court. Okay. So that concept is important. This exact 7th amendment, that is not important. So we have seen few cases like 42nd amendment and in some of the cases 44th amendment, they are important. But unlike those amendments, here the 7th amendment exact number is not important. Okay. Not important. Next, jurisdiction of Supreme Court. Entire India. Okay, entire India. So I am speaking about the territorial jurisdiction now. So Supreme Court can hear cases of any part of India, whether it is Karnataka, whether it is Union Territory like Andaman and Nicobar Islands or Lakshadweep, it can hear cases from any part of India. Okay, any part of India. But when it comes to High Court, co-terminus with the state territory, it means Karnataka High Court. So what is the jurisdiction of Karnataka High Court? Only Karnataka. Okay, Karnataka. Or concerned states and union territories if common. Okay, if you look at Assam High Court, so multiple, its jurisdiction extends to multiple states. So there it extends to all the states. Okay, so jurisdiction extends to multiple states. Multiple states. Number of judges. So how many judges are there in the Supreme Court? So originally in the constitution it was mentioned that 1 plus 7. So 1 plus 7 means one person will be called as Chief Justice of India. Chief Justice of India. So other will be other judges. Okay, other judges. So Chief Justice of India, he plays a very important role. So he will be like head of the department. Okay, he will be like head of the department. So Chief Justice of India, he will assign the cases. Means which case should be handled by which judge. So all these things are done by Chief Justice of India. Number of judges. Empowered Parliament to increase through ordinary act. So this is very important. From exam point of view, this point is very important. Means who has the power to increase the number of judges of the Supreme Court? So option number 1, President. Option number 2, Parliament. Okay, in that fashion they may frame a question. So we should have a crystal clear clarity that it can happen through Parliament. It means Parliament will pass a law called as Supreme Court Judges Increase Bill. Okay, so this bill has to be passed by Lok Sabha. This bill has to be passed by Rajya Sabha. Then President has to sign it. Then the number of judges will increase. The number of judges will increase. So just out of curiosity, what I have added here is, so how many times such increase in the number of judges have taken place? So totally 6 times. Okay, 6 times. So presently it is 34 judges. Okay, 34 judges. So what you have to do every year, you have to again check, because of if you have not gone through the current affairs, if you have missed the information, you have to check whether any amendment has taken place with respect to the increase in the number of judges. Okay, increase in the number of judges. So if it is 34, if they have increased, again you have to update the content. Okay, you have to update the content. One more important here is through ordinary act. Means to, now again the examination they may frame a question like this. To increase the number of judges in the Supreme Court, we require a constitutional amendment. True or false? False. We do not require a constitutional amendment. Okay. Any change will not take place in the constitution. It will happen through an ordinary act. Okay. Ordinary act. So when I say ordinary act, so what kind of majority is required in Lok Sabha? Simple majority. In Rajya Sabha, simple majority. So what are the powers available to president when it comes to ordinary bill? Can he ratify? Can he reject? Can he return? Yes. All the three options are available to president. Okay. Now, when it comes to High Court, so this is very important. 1 plus such other numbers. So originally how many, means every High Court it will change, the number of judges will change. Here what is important here is, it is discretion of president based on workload. Means who has the power to increase the number of judges of the High Court? President. Do we require a law to be passed by Parliament? No. Here president has the power. So this is a very significant difference between Supreme Court and High Court. In case of Supreme Court, the power to increase the number of judges lies with the Parliament, whereas in case of High Court, it lies with the president. Okay, president. So this is the crux. Okay. Next, appointment of judges. Okay, appointment of judges. So judges, Supreme Court judges are appointed by president. High Court judges are also appointed by president. Very important. High Court judges are not appointed by governor, they are also appointed by president. So next things that we are going to discuss, many times they appear in the newspaper. Many times they appear in the newspaper, and also while going through the content it appears very important. But for the past 30 years they have never asked a question. So that exams demand, you should keep it in mind. Because unnecessarily if you spend too much of time there, then you will not be able to move to the next topic. At the time of revision, when we start approaching the examination in the month of April, March or February, so we need to understand the exams demand also. The next part again you can mark, not that much important from prelims point of view. Okay, prelims point of view. So appointment by judges, appointment by president, both Supreme Court judges as well as High Court judges. Okay, appointed by president. Now, president, when we say president, whether president alone will take the decision? No. Who will take the decision? Council of Ministers headed by Prime Minister will advise the president, and based on that president will appoint the judges. Now next question is whether Council of Ministers headed by Prime Minister have the freedom to appoint any person as a judge of the Supreme Court? Okay. There should be some qualifications. That let us assume a person satisfies all the qualifications. A person satisfies all the qualifications. So can Council of Ministers headed by Prime Minister appoint any person of their choice who satisfies the qualification as a judge of the Supreme Court? No. Why? They recommend to president. That's what I am saying. They will recommend to president. Can they recommend anyone to president and president can appoint? So this is very, now see, in other cases, for example, let's assume when it comes to appointment of a joint secretary. Okay, joint secretary. So whatever the Council of Ministers headed by Prime Minister will decide, so that person will be appointed as joint secretary. No one will interfere. But in case of judiciary, we will be discussing later on that judicial independence is of very paramount importance. So why judicial independence is required, again we will be discussing in detail. Now, if Council of Ministers headed by Prime Minister, they appoint a judge of their choice, means they will recommend a judge of their choice to president. Now president will appoint that person. Now next what that judge will do, whenever a cases come to the court, so what he will do, he will always give a judgment in favor of the government. Okay. So why he will give a judgment in favor of the government? Because government has appointed him. So he will be at the mercy of the government. When he will be at the mercy of the government, he will not be able to take independent decisions. So hence, the body like Supreme Court and the judges who are present there, they should be completely independent. They should not be at the mercy of the executive. Okay. Hence, just for name's sake, we say that president is going to appoint, but internally the procedure is different. Again, we will understand that the most powerful bodies in India are Supreme Court and High Court. Okay, because already we have seen the power of judicial review. So any law enacted by the Parliament can be declared as invalid by Supreme Court. So such a powerful body it is. So here, even though we say president, it is just namesake. Okay, namesake. Actually, process is bit different, and we will be discussing about that process. Okay, that process. So as per the Constitution, president, while appointing Chief Justice of India, who will appoint? President, for namesake. But before appointing, he has to consult few people. Who are those few people? such judges of Supreme Court and High Court as he deems necessary. So this is mentioned in the Constitution. So what the Constitution says, President before appointing Chief Justice of India, he has to consult Supreme Court judges and High Court judges. But how many Supreme Court judges and how many High Court judges? There is no clarity. Okay, there is no clarity. Just they have mentioned that President before appointing the Chief Justice of India, he has to consult few Supreme Court judges and few High Court judges. But how many Supreme Court judges, how many High Court judges? There is no clarity. Okay, there is no clarity. When there is no clarity, who has the power to interpret the Constitution? Parliament has the power to interpret the Constitution. Within the House they can interpret, but for entire India, who has the power to interpret the Constitution? Supreme Court itself has the power to interpret it. So what the Supreme Court did? Okay. So first, before that, okay, other judges. So when it comes to Chief Justice of India appointment, so we saw there are 34 judges. So one is Chief Justice of India, 33 other judges. Okay, other judges. When it comes to appointment of Chief Justice of India, President has to consult High Court judges and Supreme Court judges. Similarly, when it comes to appointment of 33 other judges, so President has to consult Chief Justice of India. It is mandatory. Okay, he has to consult Chief Justice of India, and this consultation is mandatory. Plus, such other judges of Supreme Court, means few other judges of Supreme Court and few other judges of High Court as it deems necessary for President. Again, there is no clarity here. Okay, because exactly how many judges, they are not mentioned. Okay, they are not mentioned. Hence, what was required? An interpretation of the Constitution was required. Someone was required to interpret the Constitution. Hence, Supreme Court. So here we come across three cases: first judge case, second judge case, and third judge case. So here this third judge case is important. So what is that 1, 2, third judge? Don't worry about it. Just what I had this information, third judge case. So in third judge case, one case went to Supreme Court. So Supreme Court, it made an interpretation of consultation. So what should we understand when we say consultation? Okay, because in Constitution there is no clarity. Such number of Supreme Court judges and such number of High Court judges as it deems necessary for President. To give clarity, so what they said is third judge's case and CJI consultation for recommending judges of Supreme Court and High Court. Okay. Okay. So President, let's assume we want to appoint one judge to Supreme Court. Okay, judge to Supreme Court. So what we have seen in the previous, compulsorily he has to consult Chief Justice of India. Okay, Chief Justice of India. Next, Chief Justice should consult 4 senior most judges. Now, Chief Justice of India, he will give some recommendations to President. He cannot give it alone. What he has to do? He has to consult 4 senior most judges: Judge 1, Judge 2, Judge 3, and Judge 4. Okay. So he has to consult 4 senior most judges. Even if 2 judges give adverse opinion, he should not send recommendation to government. So here government means President. Okay. Now Chief Justice of India, he'll consult 4 senior most judges. So let's assume all the 4 will say yes to person A. So this person A can be appointed as a judge of the Supreme Court. So what Chief Justice of India will do? He'll send this person A's name to President, and President will appoint him. Let's assume 3 members say yes and 1 member says no. Then also Chief Justice of India will send the A's name to President, and President will appoint him. But if 2 say yes and 2 say no, then what happens? Even if 2 judges give adverse opinion, 2 are saying no. In such a case, Chief Justice of India should not send recommendation to President. Okay. So if not done, then it's not binding on government. So even if when 2 members say no, then also Chief Justice of India sends the name of person A to President, then it is not binding on President to appoint him. Okay. It means when all the 4 people say yes and the name of A is sent to President, whether it is binding on President? It is binding on President. When 3 members say yes and Chief Justice of India sends the recommendation to President, whether it is binding? Binding. When 2 members say yes and 2 members say no, and in that case when Chief Justice of India sends the recommendation to President, Whether it is binding, it's not binding. Okay, binding. So there is a bit of complexity involved here, but in the examination they are not going to focus to such a deeper level. This you have to understand. Because unnecessarily if you start taking multiple examples and start wasting your time, so please don't do it. So we can productively go for some other concept which has a very high priority of getting what, fetching more marks. Okay, fetching more marks. So just we need to understand here is that, so in third judge's case, it was mentioned that, it was interpreted that Chief Justice of India consultation means he has to internally consult 4 senior most judges. Okay, 4 senior most judges. Okay. Similarly, when it comes to High Court, so when it comes to appointment, again in case of High Court also, let's assume Karnataka High Court. Karnataka High Court. So we have one Chief Justice plus other judges. Okay, other judges. So while appointing Chief Justice of Karnataka, President has to consult Chief Justice of India. While appointing Chief Justice of Karnataka, President has to consult Chief Justice of India, that is Supreme Court. Supreme Court Chief Justice. Next, Governor. So he has to also consult Governor of Karnataka. And if common, for example, if we take the example of Assam, which is a common high court for multiple states, then he has to consult the governor of all the states. Okay, governor of all the states. Again, this is mentioned in the constitution. For other judges, so this is for Chief Justice of Karnataka High Court. For other judges of Karnataka High Court, so President has to consult governor, sorry, he has to consult Chief Justice of India, he has to consult governor, and if common, all governors. Next, Chief Justice of that High Court. Okay, so when we are appointing other judges of the Karnataka High Court, so who all he has to consult? Chief Justice of India, Governor, and next Chief Justice of Karnataka High Court. Okay, Karnataka High Court. Again, they are given here. Again, you have to understand, to such a deeper level, they have never asked a question. Never asked a question. Again, in third judge's case, interpretation was given like this. So CJI should consult 2 very senior judges of Supreme Court. So in case of appointment of High Court judges, so President has to consult Chief Justice of India, right? So when we say consultation of Chief Justice of India, so it means Chief Justice has to consult 2 senior most judges. So here at a superficial level you can understand. When it comes to appointment of judges of the Supreme Court, when it comes to appointment of judges of the Supreme Court, so CJI consultation means Chief Justice of India has to consult how many judges? 4 senior most judges. When it comes to appointment of judges of High Court, so the consultation means Chief Justice of India has to consult how many judges? 2 senior most judges. So at this superficial, just retain this superficial information. That would be sufficient. Okay, that would be sufficient. Next, third judge case, one more important point is transfers. So initially in the constitution, there was no mention about the transfer of judges. Okay, there is no mention of transfer of judges. So transfer facility is not applicable to Supreme Court because there is only one Supreme Court. But in case of High Court, whether a judge can be transferred, yes, transferred, and in the recent years there are few instances wherein judges were transferred from one High Court to another High Court. Hence it is important. Okay, hence it is important. So the interpretation with respect to transfer of judges, it became final in which case? Third judge case. Okay, third judge case. Only as public interest, not as punishment. Okay. So as per the constitution, so generally when judges commit any kind of mistake also, we will not say that we have transferred him because of committing mistake. When it comes to government officer, so generally they will be transferred based on some mistakes that they have committed. But here they will be transferred, means government officers will be transferred as a punishment. But here, even though judges when they are transferred, will not say that for the sake of punishment, but as public interest. So what is it public interest and what is punishment, what is the difference, we will not go into the deeper aspects. Only we shall understand that whether a High Court judge can be transferred on the grounds of punishment? No. Can a High Court judge can be transferred on the grounds of public interest? Yes. Okay. Judicial review, whether judicial review is applicable? A judge will be transferred from one High Court to another High Court. Can he challenge in the Supreme Court that my rights have been violated? Yes, is it subject to judicial review? Yes. Okay. So in this case, when a judge is being transferred from one high court to another high court, who will transfer? President will transfer. But again, President, before transferring, what he has to do? He has to consult Chief Justice of India. So Chief Justice of India should consult 4 senior most judges of Supreme Court and Chief Justice of High Court's source and destination. For example, from Karnataka High Court, if a person is being transferred to Punjab High Court, then apart from consulting 4 senior judges of Supreme Court, President should also consult what? Karnataka's Chief Justice and Punjab's Chief Justice, because the person is going from Karnataka High Court to Punjab High Court. Okay, Punjab High Court. Okay. Now again, we discussed all these things. Okay, but again, when it comes to appointment of Chief Justice of India, it is a convention that only the senior most judge should be appointed as Chief Justice of India. Okay. So it was declared in second judge case. Only senior to be made Chief Justice of India. If that is the case, then why do we require all the consultation, all the third judge's case, right? Because if you are going to appoint the senior most judge itself as Chief Justice of India, then all the process will become redundant. Hence, whatever we discussed is not that much important, because presently only the senior most judge will be appointed as the Chief Justice of India. So this convention was broken once during the time of Indira Gandhi. Okay, during the time of Indira Gandhi, so rather than appointing the senior most judge as the Supreme Court of India, she appointed a junior, because he had ruled he had ruled in the government's favor in one of the cases. Okay, in one of the cases. So after that, what the Supreme Court did is, it came up with the judgment. In which case? Second judge case. And it said explicitly that only senior most judge can be appointed as a Chief Justice of the Supreme Court. Okay, Supreme Court. So after the Indira Gandhi's government, many governments have come, but all of them have followed the convention of appointing the senior most judge of the Supreme Court as Chief Justice of India. Okay. Hence, whatever we discussed until this point, so it's not that much important, especially from prelims point of view. If you are writing an answer in the mains for the evolution of the appointment of judicial process, then you can mention those points. Otherwise, from prelims point of view, it carries less weightage. Okay, less weightage. Next, second judge case. So senior most judge of a Supreme High Court being appointed as a judge of the Chief Justice of a High Court, such case does not exist. So it is not applicable. It means second judge case of only senior to be made the Chief Justice is not applicable to High Court. It's only applicable to Supreme Court. So in 2015, probably in 2015 or 16, Parliament came up with an important law. But now we will not be going into the details of those laws, that law. But at that time it was a very hot topic. So what was that? The important provision was that now we understood the judicial appointment process. So in the appointment of judiciary, who plays an important role? Judiciary itself or executive or Parliament? While appointing the judge, whether Parliament has to pass a law saying that we are going to appoint so and so person as a judge? So Parliament has no role to play. While appointing a judge, whether Council of Ministers headed by Prime Minister will recommend the person and based on that President will select? No. In case of ministers, yes, Prime Minister's recommendation will work. So whosoever is recommended by Prime Minister, that person will be appointed as Minister by President. But in judge's case, what we saw, that executive does not have any kind of role. Executive cannot propose a name of any judge to President. It means executive does not have any role in the appointment of the judges of the Supreme Court and High Court. But now, through 99th Constitutional Amendment Act, 99th Constitutional Amendment Act, and also one more special act it brought called as National Judicial Appointments Commission Act. So in 2015, so government brought two things. One is 99th Constitutional Amendment Act, and along with that it also brought National Judicial Appointments Commission Act. So just at the superficial level, what the act consisted of was, it said that a team should be formed. In this team, there should be Chief Justice of India, there should be Prime Minister, Okay. There should be Prime Minister, there should be Home Minister, and few other people. So all these people, they should sit together and they should decide, okay, a name to be appointed as a judge of the Supreme Court and High Court. This body will send a recommendation to President. Okay, President. So these provisions were brought under National Judicial Appointments Commission Act and 99th Constitutional Amendment Act. So what does it mean? Executive has a role to play in the appointments of the judiciary, because previously Prime Minister did not have a role, Home Minister did not have a role. But as per the National Judicial Appointments Commission Act, so Executive has a role in the appointment of the judges of the Supreme Court and High Court. Now this entire act and 99th Constitutional Amendment Act was declared as unconstitutional and void. So this indicates the power of the Supreme Court. So the law which was made by Parliament, the law which was passed by Lok Sabha, okay, with special majority in Lok Sabha, with special majority in Raj Sabha, and also they brought an ordinary bill called as National Judicial Appointments Commission Act. So all these things were declared as invalid and void, unconstitutional. So Supreme Court, hardly around 7 or I don't know how many members were there as part of this bench, 7 judges or 9 judges, they together decided that this is unconstitutional. So it means their power is on top of the elected representatives, around close to 350 elected members of Lok Sabha and close to around 200 members of Raj Sabha. They had voted, but in spite of that, that bill was declared as invalid. That bill was declared as unconstitutional. So this indicates the power of Supreme Court. Okay, this indicates the power of Supreme Court. So once the Supreme Court or High Court, especially Supreme Court, it declares a law as unconstitutional, that will not come into force. Hence, this constitutional amendment and this did not come into force. Okay. So what was the reasoning given by Supreme Court? The reasoning given by the Supreme Court was that they would affect the independence of the judiciary. They said that if we give executive the power in the appointment process of the judicial members, that is Supreme Court judges and High Court judges, it is going to compromise the independence of the judiciary. Okay, independence of the judiciary. Now it comes to book, they have given a page full of information. They have given detailed provisions of the National Judicial Appointments Commission Act. They have given some of the provisions of 99th Constitutional Amendment Act. Now it's a 2015, it has already been declared invalid. So it's not important. Maximum what they can ask in prelims is, so what does 99th Constitutional Amendment Act deal with? Maximum. It deals with the judicial appointment process. That's it. Even in the mains also, when you are writing an answer, when it comes to independence of the judiciary, so what are the various measures that were taken to uphold the independence of the judiciary? So various points we will be quoting. In those points, in between, somewhere we will quote that Supreme Court has declared 99th Constitutional Amendment Act and National Judicial Appointments Commission Act as invalid. That is more than sufficient. So the content which is present over here, it is more than sufficient for both prelims as well as mains. Because why I am telling you, now when you start referring some current affairs notes and all of some institute, so for one single National Judicial Appointments Commission, we have 2 pages of information. And every point which is present over there, it starts appearing as important for you. So you will not be able to judge as to what is important, and you will not be able to prioritize which is important, what is not important. So you will be stuck there itself. So that's why I am mentioning. So this much point is more than sufficient. Okay, more than sufficient. So the same is applicable to High Court as well. The same is applicable to High Court as well. So even in the appointment of judges of the High Court also, executive does not have any role. So what do we understand by executive here? Council of Ministers headed by Prime Minister. Okay, headed by Prime Minister. So Supreme Court of India replaced which institution? Federal Court of India. Federal Court of India was established through which act? Government of India Act 1935. Next, High Courts were established at which places in which year? Calcutta, Madras and Bombay. In which year? 1862. Next, how many judges are there in Supreme Court presently? 34. Next, who has the power to increase the number of judges of the Supreme Court? Parliament. High Court? President. Who appoints the judges of Supreme Court and High Court? President. Presently, executive plays a very important role in the appointments of the judges of the Supreme Court and High Court. Okay. So, President consulting Chief Justice of India, and Chief Justice of India in turn consulting how many judges for the appointment of judges of Supreme Court? 4 senior most judges. So this system, actually I forgot to mention here, but generally in the current affairs, whenever article appears in the newspaper, we call it as a collegium system. Okay, collegium system. So this collegium system means not only Chief Justice of India, consultation of 4 senior most judges. We call it as collegium system. Okay, collegium system. Next, qualifications. So some of the qualifications will be very obvious. So a person should to become a judge of the Supreme Court, he should be a citizen of India. Very obvious. Okay. Again, same here. Okay. Citizen of India, citizen of India. A person to become a judge of a Supreme Court, he should have already served as a judge of High Court for 5 years. Okay. A person who has already served as a judge of High Court for 5 years, he is eligible to be appointed as a judge of the Supreme Court. Let's assume he has not served in the High Court for 5 years as a judge. He has not got an opportunity. Then the other case is, he should have served as an advocate in High Court for 10 years. So both the conditions should not be true. If one of them is true, it's sufficient. Either he should have served as a judge of the High Court for 5 years, or he should have served as an advocate in the High Court for, he should have practiced as an advocate in the High Court for 10 years. Okay. Next, or he should be a distinguished jurist in the eyes of the President. Now just don't go into the deeper aspect of what is a distinguished jurist. A person who has a good experience when it comes to judicial related things. Okay, we call him as distinguished jurist. They are not given the definition of distinguished jurist, just memorize this thing. So whether President can appoint a distinguished jurist as a judge of the Supreme Court? Yes. Now when it comes to High Court, no such provision. The second one, that is he should have served as a High Court judge, it is not applicable. Third, this is important, he should have served in High Court as an advocate for 10 years. Okay, such person is eligible to be appointed as a judge of High Court. Okay, so here same indicates what? He should have practiced as an advocate in a High Court for 10 years, then he is eligible to be appointed as a judge of the High Court. Okay, High Court. Distinguished jurist provision is there for Supreme Court. No jurist here. This is very important. Why it is important? Because the appointment of a distinguished jurist as a judge of the Supreme Court is possible, but the appointment of a distinguished jurist as a judge of the High Court is not possible. Such provision does not exist. Here it exists, here it does not exist. Held a judicial office in the territory of India for 10 years. Okay. So here we have seen advocate in High Court. So judicial office, what is that judicial office? We don't have that clarity. So let's assume here judicial office means, let's assume some district court. If he has served as a judge of the district court for more than 10 years in any part of India, then also he can be appointed as a judge of the High Court. So here rather than saying district court, you please memorize this part, judicial office. He has held judicial office in the territory of India for 10 years. Okay, for 10 years. So they are also eligible. Next, appointment of both Supreme Court judges and High Court judges is made by President. But when it comes to oath, so oath to Supreme Court judges will be administered by President, whereas oath to High Court judges will be administered by Governor. What is oath? Yes. So initially when they come to office, the promise that they make, okay, so that you call it as oath. So oath is administered by President here and here by Governor. Next, tenure is 65 and 62. So unlike other posts wherein we say that minimum he should have been 30 years old, 40 years old, so that minimum age related criteria does not exist. It means to become a judge of Supreme Court, either he can become at the age of 40 or 50 or 57, it does not make difference. Even at the age of 60 as well, he can become judge of the Supreme Court. So if a person becomes a judge of the Supreme Court at the age of, let's assume 60, for how many years he will serve as judge of Supreme Court?
5 years.
From 60 to 65, 5 years. If he becomes judge at the age of 57, he will serve for approximately 7 to 8 years. Next 50 means 15 years, 40, 25 years. Okay. So when he attains the age of 65, okay, then he will retire. Okay, he will retire. when it comes to judge of High Court, it is 62. He can become a judge of High Court at any age, but he will retire at the age of 62. 62. So person is, let's assume he is running 61. Okay, 61. So if he is appointed a judge of Supreme Court now, what happens? Now he can work as a Supreme Court judge till he attains the age of 65. 65. Question of age determination by age determination. Okay, again this point is not important. So how you are going to determine that whether his age is 65 or 64? So generally it happens to the 10th marks card, right? So whatever is mentioned there, it happens to that. But again, if there is no proper 10th marks card also, who is going to decide it? By such authority as provided by the Parliament. So Parliament will fix an authority, they will decide it. So not an important point. Okay, not an important point. So here in case of High Court judge, President after consultation with Chief Justice of India. I don't know why such a process is required, because generally when we look at the marks card, everything, all the details are mentioned. So probably if the details are missing, then it will be decided by President after consulting with Chief Justice of India. Okay. So President decision here, it is final. When it comes to High Court judge, whether he has attained 61 or 62 or 60, so President's decision is final here. Final. Resign by. So he can send his resignation to whom? Supreme Court judge, to President. Similarly, High Court judge will submit his resignation to President of India and not Governor. Oath is administered by Governor, but resignation will be sent to President. Vacates his office. Okay. So here not applicable. Why not applicable? Because there is no provision of transfer. Okay. But here, when appointed as a judge of Supreme Court, then that position will become vacant. Okay, one. Next, or transferred to other High Court. Okay, so a Supreme Court judge cannot vacate his office. He can just resign. He cannot just vacate his office. But here, again, don't go to the deeper meaning. What is the difference between resignation, vacating the office and all? But here it is possible, because a judge of the High Court can be appointed as a judge of the Supreme Court. One High Court judge can be transferred to another High Court. Okay, another High Court. Next, grounds of removal. Whether President, judges of the Supreme Court and High Court can be removed. Yes, they can be removed. Forcefully they can be removed. Okay. Again, we will be discussing about that process in detail. But what are the grounds of the removal of President? Proved misbehavior or incapacity. While discussing about the other constitutional bodies, we have discussed about the grounds for the removal. For example, when it comes to removal of President, what is the ground? No, what is the ground? Reasons. Violation of the Constitution. When it comes to removal of Vice President of India, what are the grounds? What are the grounds, on which grounds Vice President of India can be removed? There are no grounds. There are no grounds specified in the Constitution. When it comes to President, they have mentioned violation of the Constitution. But when it comes to Vice President of India, they have not mentioned any such grounds. Here similarly, such grounds for the removal of the judges of the Supreme Court and High Court are same. That is proved misbehavior or incapacity. What is proved misbehavior? What is incapacity? Again, they are not given the definition. Okay, they are not given the definition. So how they are going to be removed? We will be discussing those steps one by one. So grounds of removal of Supreme Court and High Court judges is proved misbehavior or incapacity. So next, so grounds of removal is proved misbehavior or incapacity. So we also saw that President can remove the judges of Supreme Court and High Court. Next is, what is the removal procedure? Removal recommendation by address supported by special majority of each House of Parliament and presented to President in the same session. It's very important. So when President has to remove a Supreme Court judge, so what is the process? Lok Sabha and Raj Sabha, both of them, they have to pass a resolution. They have to pass a resolution with what kind of majority? Special majority they have to pass. Raj Sabha should also pass it with special majority. Okay, special majority. So this resolution has to be passed by Lok Sabha by special majority, Raj Sabha by special majority, and also it has to be given to President in which session? Same session. So we have seen during the discussion of Parliament that generally we have how many sessions? 3 sessions. Which are the sessions? Budget session, monsoon session and winter session. If this resolution is moved in winter session, let's assume budget session, next monsoon session. So if this resolution is moved by both Lok Sabha and Raj Sabha in winter session, then the same session during that time itself it has to be presented to President. So you will pass the resolution in winter session and you cannot give to President in budget session. Okay, so that is also very important. Address supported by special majority. So address means resolution. Resolution supported by special majority of each house of parliament and presented to President in the same session. So once President receives it and President removes the judge, then that is final. Okay, that is final. Similarly, the same process is applicable to judges of High Court as well. So the process of removal of judges of Supreme Court and judges of High Court is same. Okay. So here Legislative Assembly cannot pass a resolution. Legislative Council cannot pass a resolution. For the removal of judges of High Court also, Lok Sabha and Raj Sabha have to pass a resolution with what kind of majority? Special majority, and it has to be presented to President in the same session. Okay, same session. Next, another important part here is, so we saw that it has to be supported by special majority of Lok Sabha and Raj Sabha. But apart from that, there is one more act that is called as Judges Enquiry Act. Now immediately you will get to know that proved misbehavior or incapacity, but you have to prove it, right? So how you are going to prove? So to prove that a separate law was made to understand whether he is incapable or whether there is a proved misbehavior. For that a separate act was made, that is called as Judges Inquiry Act. So whatever we are discussing here, it is not part of the Constitution. It is not part of the Constitution. It is part of what? Judges Enquiry Act. Okay, Judges Enquiry Act. So under this act, they will study whether a proved misbehavior has taken place or not. So whether a judge is incapable. Okay, incapable. So here, removal motion. So removal motion, it has to be passed by what kind of majority? Special majority. Now let's assume in Lok Sabha, one person will stand and will say, I want to move a motion for removing the judge of the Supreme Court. So we already discussed about the motions. So when it comes to Lok Sabha, so who has to accept the motion? Speaker has to accept the motion. Then he has to fix the time. So if one single member of Lok Sabha says that I want to pass a motion for the removal of the judge of the Supreme Court, will it be acceptable? No. So it is mentioned that minimum 100 members of Lok Sabha should write a letter, should sign it, say that we want to move a motion. Only such motion can be accepted by Speaker. Okay, Speaker. Now this removal motion, whether it has to be moved in Lok Sabha only, it can also be moved in Raj Sabha as well. So first it has to be moved in Lok Sabha or in Raj Sabha. Any house, either Lok Sabha or Raj Sabha. So if it is first moved in Lok Sabha, then minimum 100 members should support it. Okay, to submit it to Speaker. If it is being moved in Raj Sabha, 50 members. Okay, 50 members. Now let's assume 100 members of Lok Sabha. First, they will sign and they will submit it to Speaker. Now whether it is compulsory for Speaker to accept it, Speaker may admit or refuse. Speaker may say, no, I am not going to admit it. Okay, Speaker may admit or Speaker may admit it or he may say, no, I am not going to admit it. He may refuse it. Okay, he may refuse it. Similarly, in case of Raj Sabha also, Chairman may accept the request or he may not accept the request. He may admit or he may refuse. Okay, he may refuse. So let's assume Speaker or Chairman, they admit the request. So 100 members in Lok Sabha, they submitted a request to Speaker. Speaker admitted it, accepted it. Now if he accepts, what he can do? He will constitute 3-member committee. 3-member committee. So that committee consists of Chief Justice or a Judge of Supreme Court. Okay, 3-member committee will be there. One person will be, either he will be a Chief Justice of a Supreme Court or a Judge of Supreme Court. Next, Chief Justice of a High Court. and a distinguished jurist. So what is this distinguished jurist? Will not worry about it. It means 3 member, one from Supreme Court, one from High Court, and one distinguished jurist. Okay, jurist. Now these 3 people together, they will study the charge. What is the charge? Proved misbehavior or incapacity. That is the allegation, right? They'll study whether proved misbehavior has taken place or not. So after studying, if they feel that yes, proved misbehavior has taken place, then they will submit a report to Lok Sabha. Okay, Lok Sabha saying that yes, proved misbehavior has taken place. Now once it happens, now what the Lok Sabha will do? Now it will pass a resolution with what kind of majority? Special majority. Okay, special majority. Now a judge of a Supreme Court and High Court can be removed by special majority, whether it is mentioned in the Constitution. Yes, it is mentioned in the Constitution. So for removing the judges of the Supreme Court and High Court, a 3-member committee has to be formed. Whether it is mentioned in the Constitution? No. It is mentioned in which act? Judges Enquiry Act. So before the investigation of the charges take place, a motion has to be submitted to the Speaker by Lok Sabha. So minimum how many members have to submit the motion? 100 members. If it is initiated in Raj Sabha, 50 members. So once it is submitted, whether Speaker or Chairman, compulsorily they have to admit or they can refuse. Okay, they can either admit or they can refuse. Once they admit, they will form a 3-member committee. So these 3-member committee will submit the report saying that yes, so proved misbehavior has taken place. So based upon that, Lok Sabha and Raj Sabha, they will pass that resolution with special majority. After that, they have to submit it to President within the same session or any session? Within the same session. Then the judges will be removed. Okay, judges will be removed. Yes. What happens? Then the process will stop. Will not go to that point. He may be, but will not go to that point. Will stop here itself. Because once the Speaker refuses it, then the process will not move forward. It will stop there itself. Means that judge cannot be removed now. Again, once more time, again they can submit it again after few days. But once the Speaker refuses it, now next your question will be, sir, once the Speaker refuses it, again after how many days they can submit one more motion? That is beyond the scope of our discussion. Okay, so as an UPSC aspirant, we'll stop at this point. Those who are constitutional experts, they'll be going into the technicalities. But again, your question is valid because initially when you are reading, all these questions will arise. And some questions have to be answered, some questions have to be suppressed. Because if we start finding and exploring the answers to these questions, probably we will not get answers and we will be stuck here itself. Okay, we'll stuck here itself. What we need to know here is whether Speaker has the power to refuse. Yes, he has the power to refuse. Salary and allowances. Now, who is going to fix the salary of the judges of Supreme Court? Parliament. Okay. Similarly, who is going to fix the salary of High Court judges? Parliament. Okay. Next, we will see who will pay the salary. Fixing is done by Parliament, but who is going to pay the salary of judges of High Court? It is state consolidated fund of state's consolidated fund. State government will pay the salary. But when it comes to pension, okay, consolidated fund of India. When it comes to Supreme Court judges salary, consolidated fund of India. Next, pension, consolidated fund of India. Okay. Next. So these 4 are often confusing but important from exam point of view. Okay, see here. Acting Chief Justice, ad hoc judge, additional judge, and next is acting judges. Now, let's assume in Supreme Court, Chief Justice position is vacant. Okay, vacant. So, probably Chief Justice of India, he has resigned, let's assume, if he has resigned, one case, at that time the position will become vacant. Next is, he is absent temporarily. So, because of some marriage or some other affair and all, he is attending his native place, so he is out of the office. So, absent temporarily. The third one is unable to perform. So, probably he is not feeling well, he is admitted in the hospital, so he is unable to perform. In such cases, there should be a Chief Justice of India. So we do not have sufficient time to appoint the Chief Justice of India. Okay, Chief Justice of India. So in between that period is there, right? We require a person who is going to act as Chief Justice of India. So that person is called as Acting Chief Justice. Acting Chief Justice of India. He is not a permanent Chief Justice of India. He is called as Acting Chief Justice of India because he has been appointed temporarily. Now question is, who is going to appoint him? President. Okay, President. Now again we will stop here itself. So in this case, whether he will consult the Chief Justice of India, whether Chief Justice of India is going to consult 4 senior most judges, that is beyond the scope of discussion, because human brain continuously it will be bombarded with so many questions that it wants to go to the deepest extent. But here we will stop. What we have to understand here is the provision of Acting Chief Justice, whether it is applicable to Supreme Court, yes. Whether it is applicable to High Court, yes. In case of Supreme Court, who is going to appoint the Acting Chief Justice? President. In case of High Court, who is going to appoint the Acting Chief Justice? President. Okay. In case of President. That's it. So Acting Chief Justice is applicable to both. Appointment of Acting Chief Justice is applicable to both Supreme Court as well as High Court. Okay, High Court. Next, ad hoc judge. Okay. First you retain this information. It's not applicable to High Court. Now don't ask a question why it is not applicable to High Court. That is again beyond the scope of our discussion. Okay. So ad hoc judge provision is not applicable to High Court. Okay, is not applicable to High Court. So what is ad hoc? Okay. For some purpose temporarily that we are going to appoint, we call it as ad hoc. It's a generic English word called as ad hoc. Okay, ad hoc. Chief Justice of India can appoint a judge of a High Court for a temporary period. Okay, for a temporary period. For a temporary period. When? If lack of quorum. Okay, lack of quorum. So while discussing about the parliament, if you remember, there is a concept called as quorum. So what is quorum? 1/10. So if you look at Lok Sabha, so out of 545 members, minimum 55 members should be present to carry out the discussions. Okay, to carry out the discussions. Similarly, in Supreme Court, to carry out the day-to-day affairs, let's assume around in 34 judges, at least let's assume 15 judges or 20 judges should be there. Okay, with less than 20 judges, we cannot carry out the work. So presently, let's assume there are only 15 judges. There are 15 judges. There are 15 judges. Still, we require around 19 more judges. Okay, 19 more judges. Just imagine an example I have taken to carry out the work. Not 19 judges. Okay, in this example, what I took, 20 is the quorum, right? So minimum 20 judges are required. So in our case, only 15 are present. So out of 34, 20 is the required quorum, but only 15 are present. So 5 more judges are required. So temporarily to fill the quorum. So few of them may be absent for 2 to 3 months, or they may be on leave. We want to fill that quorum. So in that case, judge of a High Court will be appointed as an ad hoc judge. So let's assume Karnataka High Court. In Karnataka High Court, let's assume there are around 10 judges. So among these 10 judges, one person will be appointed as an ad hoc judge to Supreme Court. Okay. So who is going to appoint here? President or Chief Justice of India? This is very important. In case of Acting Chief Justice, who appointed? President. When it comes to ad hoc judges, Chief Justice of India can appoint a judge of a High Court for a temporary period. Next, before appointing, he has to consult Chief Justice of the concerned High Court. It means he has to consult which High Court? Karnataka High Court's Chief Justice he has to consult. Okay, he has to consult. Previous consent of President. This is also important. Before doing this process, he has to also take the permission of the President. He has to also take the permission of the President. From the exam point of view, if you think, if they make a statement, who among the following is involved in the appointment of the, who among the following appoints the ad hoc judges of Supreme Court? If they give two options, one is Chief Justice of India, another one is President. Chief Justice of India. Next, in the next statement, if they frame, so while appointing, he need not take the consent of the President. True or false? False. So appointment is done by Chief Justice of India, but he has to take the consent or permission of the President, and also he has to consult Chief Justice of the respective High Court. In this case, it is Karnataka. It is Karnataka. It's not applicable here. It's not applicable here. So when is ad hoc judge appointed? Lack of quorum. Okay, lack of quorum. Additional judges. Okay, additional judges. This provision is not applicable to Supreme Court. So we saw acting Chief Justice applicable to both Supreme Court and High Court. Ad hoc judges appointment applicable to Supreme Court, not applicable to High Court. Additional judges appointment applicable to High Court, not applicable to Supreme Court. Okay, Supreme Court. President can appoint. Who can appoint? President. Duly qualified person. So what is duly qualified person? So what are the qualifications to become a judge of a High Court? Citizen, this is important, citizen of India. Next. High Court, no. High Court judges 5 years, not for High Court. Advocate in High Court for 10 years. Next. Judicial office in any territory of India for 10 years. So whether there is a provision of what? The special provision which only existed for Supreme Court. Jurist provision, can he be appointed? No. So a distinguished jurist. So a person holding any of these qualifications, so he is called as duly qualified person. So such qualified person can be appointed as an additional judge by President for temporary period of not exceeding 2 years. Very important. So in case of ad hoc judges, we did not see the period 1 year or 2 year, but here they are explicitly mentioned. When it comes to additional judges, they will be appointed for a temporary period, and that temporary period cannot extend more than 2 years. Okay, more than 2 years. So why they are appointed? Temporary increase in business. So what is the business of High Court? To hear the cases. Let's assume in some particular time period, the number of cases have increased. The number of theft have increased, the number of murders have increased, so cases have increased. Hence, to address the additional load, so they are appointing additional judges, but they are not permanent judges. They are additional judges. Okay, additional judges. Arrears of work. If there is increase in business or there is arrears of work, lot of cases are pending. So we want to dispose those cases in a faster manner. Okay, faster manner. For that also we will appoint. Hold office until they are less than 62 years. This is very important. Okay, let's assume if we appoint a person who is 61 years old. Okay, 61 years old. Now if he is appointed as a additional judge, so what will be the tenure left? 2 years or 1 year? Only 1 year. Okay, a person who has been appointed as an additional judge, so he can serve maximum up to the age of 62, not beyond that. Okay, not beyond that. So this is additional judge. Okay, additional judge. So UPSC previously it has asked question on these concepts. Okay, these concepts very important. Okay, very important. So acting Chief Justice, who appoints? President. Next, ad hoc judges of Supreme Court, Chief Justice of India. Acting judges, President. Okay, President. Important. Next, acting judges. So why they have given these different terms? Again, it will cause confusion. Acting judges is not applicable to Supreme Court. It's applicable to High Court. Their additional judges, again acting judges. So what we learned here, the concept of additional judges and the concept of acting judges is applicable only to High Court. The concept of ad hoc judges is applicable to Supreme Court. Okay, Supreme Court. So President of India can appoint duly qualified person. So already we have seen what are the qualifications. When judge of a High Court unable to perform, so here not Chief Justice, because already there is a provision of acting Chief Justice we have already seen. So when judge of a High Court, other judge of a High Court is unable to perform, that is he is absent for some reason, this is one case, or appointed to act as temporary Chief Justice of a High Court. See here, now a High Court judge can also be appointed as a Chief Justice of a High Court temporarily. When Chief Justice of High Court is, for example, Karnataka Chief Justice is absent for some reasons, So that duty will be carried out by some other judge. Okay, some other judge. So when he is appointed as to act as a temporary Chief Justice of the High Court, then what happens? The position is vacant. The position is vacant. To fill that position, they will appoint acting judges. Okay, acting judges. Holds office till permanent judge resumes his office. This is very important. Now in case of acting judges, what we saw, while giving the appointment letter, you will be as a judge for so and so days. But here it is not like that. So he will stay in office as long as a permanent judge comes back. Okay, comes back. So let's assume a person, let's take two judges, Judge A, okay, Judge A. So now Karnataka High Court Chief Justice is absent. Is absent for 1 month. Karnataka High Court Chief Justice is absent for 1 month. At that time, Karnataka High Court's Judge A, Karnataka High Court's normal Judge A, he is acting as a Chief Justice of Karnataka. He is acting as Chief Justice of Karnataka. Now, whatever the role he was playing as a judge, now someone should come here. So here one person will be appointed. So this person will be appointed as what kind of judge? Acting judge. Okay, acting judge. So after 1 month of service, when person A returns back from this position, so this person has to leave the office. Has to leave the office. Okay. So appointed to act as temporary Chief Justice of High Court. So these are the cases. Then holds office till permanent judge resumes his office. Okay. Here also his age should not cross 62 years. His age should not cross 62 years. So what we saw, first is acting Chief Justice, next is ad hoc judges, next additional judges, acting judges. Okay, acting judges. When it comes to retired judges, appointment of retired judges, so it is applicable to both Supreme Court as well as High Court. Okay, appointment of retired judges is applicable to both Supreme Court as well as High Court. So here Chief Justice of India will appoint the retired judges. Chief Justice of India will appoint the retired judges with the previous consent of President. Again, from the exam point of view, if they ask who has the power to appoint the retired judges of the Supreme Court, President or Chief Justice of India? Chief Justice of India. Whether the consent of President is required? Yes, consent of President is required. Next, he can appoint retired judge of Supreme Court or High Court, qualified, very important. So in the examination they can ask like this. So when we are appointing retired judges to Supreme Court, he can be a retired judge of Supreme Court or he can be a retired judge of High Court. True or false? True. But in the High Court I have mentioned qualified. What does it mean? Yes. Now I will take two examples of High Court judges. Person A, person B. So person A has served in the High Court for 3 years as judge. Okay, 3 years as judge. Next, he has worked as a advocate in High Court for, let's assume, 7 years. Okay, 7 years. Person B, now he has worked as a judge for, let's assume, 6 years. Now among person A and B, so both of them, they have worked as High Court judges and they are retired. They are retired. Now when it comes to appointment of retired judges to Supreme Court, who can be appointed? Person A or person B? Person? Why not person A? Not qualified for what? He is not qualified to become a judge of the Supreme Court. So in this example, what A cannot be appointed as judge of the Supreme Court, but B has the qualification to be appointed as a judge of the Supreme Court. So such people of High Court can also be appointed. Okay. So retired judges, when we say appointment of retired judges to Supreme Court, both retired judges of Supreme Court and retired judges of High Court can be appointed. But the condition is that when you are appointing the retired judge of a High Court as to Supreme Court, he should be qualified. He should have the qualifications to become a judge of the Supreme Court. Become a judge of the Supreme Court. Allowance determined by President. So how much salary you are going to pay, what are the facilities you are going to provide, it is determined by President, not by Parliament. Okay, not by Parliament. An important point. Jurisdiction, powers and privileges of a judge of a Supreme Court, but not deemed to be a judge of Supreme Court. So he will be having all the powers like that of a judge of a Supreme Court, but he will not be called as judge of Supreme Court. This is very important. This is what minute difference. What is that minute difference? Will not worry. He will be having all the powers like that of a judge of a Supreme Court, but we will not call him as a judge of the Supreme Court because he is a retired judge. He is a retired judge. Next here, similarly, when it comes to appointment of retired judges to High Court, here they are not mentioned about the reason why they should be appointed. Now, Chief Justice of High Court can request with the previous consent of President. So here also when it comes to appointment of retired judges to High Court, who will appoint? Chief Justice. With whose consent? President's consent. Are retired judges of High Court that or any other? This is very important. So when retired judges are being appointed to Karnataka High Court, is it necessary that a person being appointed should be retired from Karnataka High Court itself, or any person who has retired from, let's assume, Tamil Nadu High Court can also be appointed? That or any other. Okay, he should have served as a High Court judge. He can be what? Appointed. Next, here they are not given the provision of Supreme Court judge. It means a Supreme Court judge who has retired, he cannot be appointed as a judge of High Court. Okay, judge of High Court. Allowance determined by President, same as like that. Jurisdiction powers similar to that of a judge of a High Court, but not deemed to be a judge of High Court. All the powers like a High Court judge, but he will not be called as a judge of the High Court. He will not be called as judge of the High Court. So, which are different categories we saw? Acting Chief Justice. So, who is going to appoint? President. Both the Supreme Court and High Court applicable? Yes. Next, ad hoc judges applicable to only Supreme Court. Who is going to appoint? CJI. Okay. Next, coming to additional judges applicable to High Court. Who is going to appoint? President. Next, acting judges applicable to High Court. Who is going to appoint? President. Next, when it comes to retired judges, who will appoint? CJI in case of Supreme Court and Chief Justice of High Court in case of High Court. Okay. Next, seat. So, Supreme Court, the seat lies at Delhi. So, CJI may create other based on President's approval. So, apart from Delhi, we can create some other place like benches and all at other places. But till now, they have not created such kind of benches. So, presently, Supreme Court bench only exists at Delhi. Okay, Delhi. Rules for regulating the practice and procedure. Okay. Now, what should be the practice? For example, in court, what is the process that has to be followed? So, when a lawyer comes and he has to address to the judge, so what is the format of addressing? So, whether he has to say my lord or what he has to say. So, these are all what detailed rules and regulations for the practice and procedure of the court, okay, for the court. So, these rules and regulations are not made by Parliament, they are made by Supreme Court with the approval of the President. Okay. So, rules for regulating the practice and procedure, they are made by Supreme Court themselves. Okay, Supreme Court themselves with the approval of the President. Okay, approval of the President. Now, don't go for complex things like what happens if the President says no. Okay. So, all these are what namesake. So, rules they will make, President will say yes. So, don't go into negative tone like if he says no, what happens? Okay, so we will not go to such a deeper level. Even here also they have never asked a question, but there are chances that they may ask. So maximum that they can ask is, who among the following make rules for regulating the practice and procedure of the Supreme Court? Option number 1, Parliament. Option number 2, President. Option number 3, Supreme Court. So we should be able to identify Supreme Court in consultation with the approval of President. Now next we will be discussing later on when cases are being heard by benches. Okay. So in Supreme Court and High Court, whenever a decision has to be given, it is given by a bench. Okay, we call this bench. So what is it, bench? So number of judges in a panel. So bench can be considered as a panel. Okay. So don't confuse with the regular benches we have in the classroom. So generally when we hear this term called as bench, so we'll often connect the benches of our classroom. Not like that. So here it's a group of members, a panel. Okay, panel. So in Supreme Court there will be benches of 3-member judges. So when we say 3-member bench, it means in that panel there are 3 judges. Okay, there are 3 judges. If I say 5-judge bench, there are 5 judges. 7 judge, 7 members. Now, whenever a decision has to be made, it happens through majority. If 3 judges are sitting and hearing a case, so all the 3 judges may not give similar kind of judgment. Okay, they may differ. But what judgment has to be considered as final? The majority judgment. Among 3 members, whatever 2 members say, so that is called as final judgment. So one more person, if he is against this judgment, it is called as dissenting judgment. Dissenting judgment. But what is the final judgment for us? Whatever the 2 members say, that is the final judgment. Okay, final judgment. So this is how the cases are decided in Supreme Court as well as High Court. So if there are 5 judges in a bench, then how many judges should rule it? At least minimum 3 should say yes. Then if there are 7 members, okay, 4. Okay, 4 plus 3 in that fashion. So all the decisions are made by majority. Okay, majority. And it is not necessary. Sometimes all the 5 judges may say yes. They may be in favor in a particular ruling. So that may also happen. But for a judgment to be considered as final, it should be majority judgment. Okay, it should be minimum more than 50%. Okay, more than 50%. Now there are some cases, we call them as constitutional cases. Constitutional cases. Next, there are some cases which are references made by President to Supreme Court. So now let's assume when it comes to murder related case, someone has murdered someone and the High Court has given him a sentence of 10 years. Now he will go and appeal to Supreme Court. That is not a constitutional case. So constitutional case means, for example, whether a particular law, National Judicial Appointments Commission Act, whether it is adhering to the Constitution or not. You try to check whether it is adhering to the Constitution or not through process of judicial review. So such cases are called as constitutional cases. Okay, constitutional cases, which has an impact on the Constitution. So for example, 99th Amendment Act, it has an impact on Constitution. So such cases, when they are being heard by Supreme Court, they are called as constitutional cases. Okay. Again, later on we will be looking into those as well. References made by President under Article number 143 and all. So whenever such cases are referred to Supreme Court, a bench which will be constituted to hear that case. That bench should consist of at least minimum 5 members. That is very important. For other cases, it can be less than 5 members. For example, a theft related case or a murder related case, it can have 3 members in the bench. But when it comes to constitutional cases, in a bench there should be minimum 5 judges. Okay, 5 judges. So constitutional benches consist of at least 5 judges. Okay, 5 judges. So this is not applicable to High Court. So other cases, usually not less than 3-member bench. Okay, so generally in Supreme Court, generally they will have benches wherein they have minimum 3 judges. Okay, minimum 3 judges. Okay. Next, independence of judiciary. How judicial independence is upheld. Okay. So here the same 10 points are applicable to both Supreme Court as well as High Court. So in the book what they have done, whatever the points are present in Supreme Court, the same points are also present in the topic called as High Court. So I just clubbed them together. So how independence is ensured. Okay. So these are the various points. So again, probably in the forthcoming discussion, I have elaborated on these points, but at least now let us look into these points at the superficial level. So mode of appointment. So already we have seen the mode of appointment. So who is going to appoint a judge of the Supreme Court? President. So whether executive has any role to play? No. Just for namesake we say that President is going to appoint, but the convention is that the senior most judge has to be appointed as the Chief Justice of India. And even when appointing other judges, so judges itself will have an important role and executive does not have any kind of role. So by this what we ensure here is executive will not interfere in the appointment of the judges of the Supreme Court. So if executive is interfering, then what happens? Let's assume if Council of Ministers headed by Prime Minister, if they have any role in the appointment of judges, let's assume they appoint a Judge A. Now Judge A will try to give a judgment in favor of the executive in all the cases. So if that happens, then what happens? The independence of the judiciary will be compromised. So why judge is giving judgments in favor of the government? Because they have appointed him. Now, as he is not appointed by the government, he need not be loyal to government. He will take independent decisions. So hence, the mode of appointment is one of the feature which gives independence to the judiciary. Mode of appointment is one of the feature which gives independence to the judiciary. Next, security of tenure. Now this person, when he is being appointed as judge, so they'll fix a tenure. So he will remain in the office until you reach the age of 65 years. Now if there is no security of tenure, if always government threatens the judge saying that if you are not going to give the judgment in my favor, then I am going to remove you within a span of 6 months, within a span of 1 year, then what happens? He will start giving all the judgments in favor of government. So that should not happen. So he will be a judge of the Supreme Court until he attains the age of 65 years. So in the extreme cases, he can be subjected to that removal process. But again, the removal process is not easy because it requires special majority in Lok Sabha and Rajya Sabha. So from this what we ensure here is there is a security of tenure for a Supreme Court judge. So when there is security of tenure, so he will take independent decisions. He will not be loyal to the government. He will not be loyal to the government. Hence, it ensures independence of the judiciary. Okay, independence of the judiciary. Next, fixed service conditions. So initially while appointing, they will say we will give you a big bungalow, so we will be giving you a car, so there will be so many workers in your house and all. Next, later on, when he starts giving judgment against the government, what they will do? They will say that we are not going to give you a big bungalow, you have to shift to a small house. So there will be no car, we will be giving a two-wheeler. Okay, so that is called as reducing the service conditions. Okay, what reducing service conditions. So again, if that happens, again he can rule in favor of government. Hence, fixed service conditions. Whatever you have given in the appointment order, the same conditions will be valid until he retires. So again, this is a point which ensures the independence of the judiciary. Expenses charged on the Consolidated Fund of India. CFO indicates Consolidated Fund of India. So during the discussion of Parliament, we saw when it comes to expenditure from Consolidated Fund of India, there are two types of expenditure. One is voted, another one is charged. So what is voted? The Lok Sabha has to give permission for the amount to be withdrawn from the Consolidated Fund of India. Now every month for his salary, if Lok Sabha has to give the permission, then what happens? He will be at the mercy of the Lok Sabha. Every month he has to go and sit in front of Lok Sabha, please pass a bill to so that my salary can be credited to my account. So again what happens? Then Lok Sabha will say, whatever the bill we are passing, you should not subject it to judicial review. Okay, again he will be at the mercy of Lok Sabha, Parliament or executive. So hence, expenses are charged on the Consolidated Fund of India. Means automatically every month the salary will be deducted, the amount will be deducted from Consolidated Fund of India and it will be credited to the judge's account. So here it will ensure independence. Okay, independence. He is no longer dependent on Lok Sabha. Okay, Lok Sabha. Conduct of judges cannot be discussed. So now judge will give a judgment. Now such conducts or what he did and all, it cannot be discussed in Lok Sabha and all. Lok Sabha and Rajya Sabha, they cannot discuss the conduct of the judges of the Supreme Court. So again, thinking that they will be discussing about me in the Lok Sabha and Rajya Sabha, he will not give a judgment in favor of government or Lok Sabha and Rajya Sabha. So hence, this conduct of judges also cannot be discussed in Lok Sabha and Rajya Sabha. That also upholds the independence of the judiciary. So ban on practice after retirement. A Supreme Court judge, he cannot practice anywhere in India. Okay, anywhere in India. Okay, so as a advocate, as a lawyer, he cannot practice in any of the courts, either Supreme Court or High Court. So this also what ensures independence. Because now see, when he is a judge, if he starts giving all the judgments in favor of government, then government will make a plan. So once he retires, let us hire him as a lawyer, because government spends so much amount for lawyers and all. So keeping in mind that after retirement, government is going to give all the cases to me, he may start ruling in favor of government. So hence, there is no ban on practice after retirement. He cannot practice within India. So this also ensures judicial independence. Power to punish for its contempt. Again, we will be discussing in detail. So we will be discussing contempt means when you are not obeying the orders of the court. Okay, there are two types of contempt. Again, we will be discussing later on. When court gives a judgment, if you do not obey it, that is one type of contempt. That is called as criminal contempt. Okay, sorry, that is civil contempt. One more is criminal contempt is when you start criticizing the judgment given by the Supreme Court. Again, we will be discussing later on. In such cases, anyone can be arrested or he can be punished for contempt of court. For contempt of court, again we will be discussing in detail. Freedom to appoint its staff, very important. When it comes to other government offices, it may be, for example, Karnataka administrative officers, FDA, SDA and all. So there is a separate agency which will conduct the examination. But when it comes to what people working in the court, Supreme Court and all, so they will not come through some separate examination. So Supreme Court itself will conduct the examination. Based on that, they will do the recruitment. So freedom to appoint its staff, very important, Supreme Court. Again, they need not ask the government that we are falling short of a few FDAs, few officers, please send those officers to us. No. So whenever there is a requirement, they will appoint their officers by themselves. Freedom to appoint its staff. Its jurisdiction cannot be curtailed. Again, we will be discussing in detail later on. So jurisdiction means, let's assume previously Supreme Court had the power to hear only murder related cases. Now later on, Lok Sabha Parliament gave the power to hear also theft related cases. Previously it could hear only murder related cases. Now they have given the power to hear theft related cases. It means the jurisdiction of Supreme Court is widened. Okay, widened. Curtailed means reducing the power. Once you give the power, later on you will say, we want to restrict you. You cannot hear theft case. You can hear only murder cases. That is called as curtailing. Okay. So that cannot happen. Its jurisdiction cannot be curtailed. Its jurisdiction can be expanded, but once you have given the power, you cannot take back that power. You cannot take back that power. Next, separation from executive. Okay. So judiciary is not dependent on executive. It is a separate body. So executive does not play any kind of role in the judiciary. So we saw the National Judicial Appointments Act, right? So there, what was the problem? National Judicial Appointments Act, it was declared as invalid. Why it was declared as invalid? Because the executive was interfering with the judiciary. Okay, so hence it said that the judicial independence will be compromised. Hence that law was declared as invalid. So again, this is also an important point. So there should be separation from executive. There should be no connection between executive and judiciary. Okay, judiciary. So these are the points which uphold judicial independence. Okay, judicial independence. Now in the past 30 years, they have never asked a question on this judicial independence. Some of these internal things they have asked, but directly they have not asked which of the following upholds the independence of the judiciary. They never asked, but some points, for example, they are focused on retirement, other points they have asked, again we will be discussing in detail as well. The same points are applicable to high courts as well. And these points can be quoted in mains as well. So the provisions which uphold the independence of the judiciary, if not all, at least if you are able to quote a few points, that would be sufficient. Next, expenses. Okay. So expenses charged, salary, allowance of judges and staff as well as administrative expenses. So whatever the expense is involved in Supreme Court, it may be salary of the judges or it may be salary of the other staff or some other expenditure. For example, it may be tea, coffee, anything. So all these things, they are charged on Consolidated Fund of India. Okay, they are not quoted. Similarly, when it comes to state, so it is charged on the Consolidated Fund of State. But when it comes to pension of the judges of the Supreme Court, it is Consolidated Fund of India. When it comes to judges of High Court, Consolidated Fund of India. Now again question will arise sometimes. So how about the other staff? Okay. We don't know. We will not go into those deeper aspects. So probably for other staff, Chief Justice, it will come from State's Consolidated Fund itself, even pension as well. But again, we will not ask such kind of questions. Unnecessarily we will not complicate the things. Okay. So practice after retirement. Already we have seen barred within territory of India. It means a Supreme Court judge, he cannot practice as a lawyer within India. But can he practice outside in some other country? Yes, he can practice. Next, when it comes to High Court judges, barred except Supreme Court and High Court. Very important. It means a High Court judge after retirement, he can work as a lawyer in any of the High Courts, or he can work as a lawyer in any of the Supreme Court. Okay, Supreme Court. But he cannot work as a lawyer in a district court. He cannot work as a lawyer in a taluk court and so on. So except Supreme Court and High Court, so he can work, only he can work in Supreme Court and High Court. He cannot work in other courts as a lawyer. So already we have seen, cannot be curtailed by Parliament. Parliament can extend the same. For example, we saw initially Supreme Court could only hear murder related cases. So they were given extra power related to theft as well. This is called as Parliament can extend the jurisdiction of the Supreme Court. Okay, so till now you are only hearing murder related cases. Now you can also hear theft related cases. This is called as extending the jurisdiction. But curtailing means no, you can no longer hear the theft cases. So this is not possible. Curtailing is not possible by Parliament, but extension is possible. Okay, extension is possible. Similarly, cannot be curtailed by Parliament and state legislature. That is those things mentioned in the Constitution. So here it is a bit complicated. What is that? So in Constitution, let's assume there are just a minute. Okay. So here when it comes to High Court, so cannot be curtailed by Parliament and state legislature. That is those things mentioned in the Constitution. This is very important. It means there are some things which can be curtailed. There are some things which can be curtailed. By whom? By both Parliament as well as state legislature. This is very important. Okay, which all cases, that is not important. There are some powers which can be reduced. By whom? By both Parliament as well as state legislature. So which are those? Now in the Constitution, some things are mentioned. For example, subject 1, subject 2, subject 3. So other cases I will take subject 4, subject 5, subject 6. So it means when it comes to subject 1, it is mentioned in the Constitution. So whether powers related to them can be curtailed? No. Cannot be curtailed by Parliament and state legislature. That is those things mentioned in the Constitution. These are mentioned in the Constitution. So powers related to them cannot be curtailed. Can powers related to subject 4, subject 5 and subject 6 be curtailed? Yes, because they are not mentioned in the Constitution. Now don't go into the complex things like which are mentioned, which are not mentioned. Actually from exam point of view, not important. But as they are mentioned here, just we shall have a discussion, but not important. What we have to understand here is, when it comes to curtailing of powers of the Supreme Court, whether it is possible for Parliament? No, absolutely no. But when it comes to curtailing of powers of High Court, whether it is possible? Yes, in some cases it is possible. Which are those cases? The matters which are not mentioned in the Constitution. So when it comes to curtailing, who can curtail? Both Parliament as well as state legislature. Okay, which cases Parliament can curtail, which cases state can curtail? We shall again not go into those detail aspects. Okay. In other respects, the jurisdiction and powers of a High Court can be changed by both Parliament and state legislature. Okay, it means in these cases the jurisdiction can be changed by both Parliament as well as state legislature. Okay. So here we will not go into those detailed aspects. What is that? Which powers can be curtailed by Parliament, which powers can be curtailed by state legislature? No. So at least at the superficial level we understood the difference between the Supreme Court and High Court here with respect to this aspect. So Supreme Court's power cannot be, jurisdiction powers cannot be curtailed, they can be extended, but when it comes to High Court, they can be curtailed both by Parliament as well as state legislatures. Which powers can be curtailed? Which are not mentioned in the Constitution. Those who have been mentioned in the Constitution, about them the powers cannot be curtailed either by Parliament or state legislature. Okay, state legislature. So in the previous class we started with the discussion of Supreme Court and High Court, right? So simultaneously we started with comparison. So initially we started with the background of historical background of Supreme Court and High Court. So when was Supreme Court established? In which year? 1950. It was established in 1950, right? To be specific, which date? 28 Jan. So before Supreme Court, so which institute existed? Federal Court of India. So it was established through which act? Government of India Act 1935. Next we saw the historical background of High Court as well. So High Courts were established at which place? Which all places? Bombay, Calcutta and Madras. So in which year? 1862. Then we discussed about the various features like composition of Supreme Court and High Court. So who can increase the number of judges in the Supreme Court? Parliament. So presently how many judges are there? 34. Every year it has to be updated. Okay, if there is any new changes, there are any new changes. Next, who can increase the number of judges in the High Court? Parliament or President? It is President. When it comes to increasing the number of judges in the High Court, it is President. Okay. Next, we saw the qualification required to become a judge of the Supreme Court and High Court. Right? So what are the qualifications required? At least one or two. Citizen, it's very obvious. Okay. Next, he should have served as judge in a High Court for 5 years or practiced as an advocate in High Court for 10 years. Okay. Similarly, for High Court judge also we saw the qualification. Next, we saw the removal process of Supreme Court and High Court judges, whether it is different or it is same. The removal process same. Who can remove? President. Appointment is done by President. Removal is also done by President, both Supreme Court and High Court judges. Similarly, oath. So whether it is Supreme Court judges or High Court judges, oath is also administered by President. No? So when it comes to High Court judges, so oath is administered by Governor. Okay. Next, we also saw that when it comes to removal of judges of Supreme Court, High Court, the process is not that easy. The process is a bit tedious, right? So it requires the support of both Lok Sabha and Raj Sabha with what kind of majority? Special majority, and it has to be presented to the President in which session? In the same session. Okay, same session. So in the history of India, there have been no instances where a President has been removed. So sorry, where a judge has been removed. Okay. In the history of independent India, no judge has been removed through this process. Okay. Even though some cases have gone, but they have not been removed. Okay, they have never removed it. So again, that historical example also they have mentioned in Lakshmikant. If you go through the book, they have mentioned about the Lakshmikant, in which instance what attempt was made to remove a judge, but there what happened in Lok Sabha, some of the members walked out. Hence, it did not succeed. Okay, did not succeed. Again, sometimes in the examination they may ask in that fashion as well. So in the history of independent India, how many times judges have been removed by this process? Okay, no judge has been removed by that process. Next, after that we came across what the various types of judges like ad hoc judges, additional judges, next acting judges and all. So we saw the difference between Supreme Court and High Court. Okay. So next here the comparison will end. Now, finally we discuss about the jurisdiction. So who can extend the jurisdiction of the Supreme Court? Parliament. Who can extend the jurisdiction of the High Courts? Both Parliament as well as state legislature. Who can curtail the jurisdiction of the Supreme Court? No one. Parliament cannot curtail the jurisdiction of the Supreme Court. Who can curtail the jurisdiction of the High Courts? Both Parliament as well as state legislature. On all the matters? Few matters which are mentioned in the Constitution. Not mentioned in the Constitution. So until this point we discussed in the previous class. So next we shall resume here. Now here we will not discuss with the help of comparison. We will be discussing independently. Okay, we will be discussing independently the features associated with Supreme Court and next High Court. High Court. Jurisdiction and powers of Supreme Court. So it's not a federal court like the American Supreme Court. So Indian Supreme Court is not a federal court like American Supreme Court. So recently we were discussing about the parliamentary system, probably parliamentary system itself, parliamentary system or federal system, I think federal system. In federal system we understood that in America even judiciary is federal. It means the Supreme Court which is present in America, it can only hear cases related to center. That is cases related to center's law. It cannot give judgment on the cases related to state's law. Okay, state's law. It is federal in character. But in India, the judiciary we call it as integrated. Why we call this integrated? Because Supreme Court can enforce both central laws as well as state laws, and similarly High Court can enforce both state laws as well as central laws. So here our Supreme Court is not a federal court like American Supreme Court. Okay, they never asked a question, but again out of curiosity we need to know. Okay, it's not a federal court like American Supreme Court. It's a final court of appeal like the British House of Lords. So in India, which is the final court of appeal? Supreme Court or British Privy Council? Supreme Court. Previously, whether British Privy Council was the highest court of appeal? Yes. So later on it was removed. Okay, it was removed. Now the highest court of appeal, the highest where you can go is, you can go to Supreme Court. But here again important point, because when it comes to main syllabus, they are explicitly mentioned comparison of Indian constitutional schema with that of the other countries. So we will not be comparing every provision with the constitution of every other country, but whichever provision explicitly it has been mentioned in Lakshmikant, we will focus on it. So here what they have mentioned, final court of appeal like the British House of Lords. So in Britain, again there we have upper house and lower house. Okay, lower house and upper house. In India, which is the upper house? Rajya Sabha. Similarly in Britain, the upper house is called as British House of Lords. So in Britain, if Supreme Court decision, if you are not happy, you can appeal. Whom you can appeal? You can appeal to upper house. Okay, but in India there is no such provision. If you are not satisfied with the decision of the Supreme Court, can you go and appeal to Rajya Sabha? No, there is no such provision. The highest appeal that can happen in Britain is to British House of Lords, whereas in India it is Supreme Court. Final interpreter of the Constitution. So who has the highest power to interpret the Constitution, Supreme Court or High Court? Supreme Court. Okay, Supreme Court is the highest interpreter. Even High Court also interpret, but the highest power of interpretation lies with the Supreme Court. Okay, Supreme Court. Next, guardian of Constitution. So whenever Constitution is being violated or it is being threatened, then it will act as a guardian of the Constitution. Now don't go into deeper aspect what exactly is guardian. Okay, it's a who. Now in the examination they will ask a question. So who among the following act as a guardian of the Constitution? Parliament, President, Supreme Court, none of these. Okay, Supreme Court. Again they will not ask you to demonstrate with the help of an example. So just retain this statement. Next, guarantor of fundamental rights of citizens. So whether it's a guarantor of fundamental rights? Yes, whenever your fundamental rights get violated, so where you can go? You can go to Supreme Court directly, or you have to go to first High Court and then itself by appeal you have to go to Supreme Court. So when your fundamental rights get violated, you have a choice either to go to High Court or directly go to Supreme Court. So hence it is a guarantor of fundamental rights as well. Okay, guarantor of fundamental rights as well. So again in the examination they may ask, so which of the following act as a guarantor of the fundamental rights? So multiple entities when they mention, we should be able to identify the entity, that is Supreme Court. Next, it has some advisory and supervisory powers. So which are those advisory and supervisory powers? We will be looking into it later on. So advisory means when someone is in a confusion, okay, so he will seek advice from the Supreme Court. So who will be having that confusion? Later on we will see the President of India. The President of India, whenever he has some kind of confusions, he will seek the advice from Supreme Court. So at that time Supreme Court will give the advice. Okay, again it comes under multiple parts, we will be discussing later on. Next, supervisory powers. Whether someone is working properly or not, High Courts are working properly or not, that supervision power also lies with the Supreme Court. Okay, lies with the Supreme Court. Now jurisdiction of Supreme Court. So which all cases it can hear, that is called as jurisdiction here in this context. We are not speaking about the territory, we are speaking about the subjects. So what kind of cases Supreme Court can hear? Okay, what kind of cases Supreme Court can hear? So it has been classified into various aspects. So one is original jurisdiction, next writ jurisdiction, appellate jurisdiction, advisory jurisdiction, a court of record, next power of judicial review, other powers. Okay, so now what we will do, so these are the various jurisdiction: original, writ, appellate, advisory, a court of record, power of judicial review. So we will be discussing about these aspects one by one. Okay, one by one. Again the examination they will not ask you which of the following are the various jurisdictions of Supreme Court. Okay, they will not frame such kind of questions. So just we need to know there are different types of jurisdiction, original, writ and all. So I think already we have discussed about one, if you remember. We have discussed about writ during the discussion of fundamental rights. Okay, so you can file a writ either in the Supreme Court or in the High Court whenever your fundamental right gets violated. So it means Supreme Court has the jurisdiction over the matters related to fundamental rights. So that speaks about the jurisdiction. Okay, jurisdiction. Now we'll discuss one by one. First we'll start with original jurisdiction. Okay, so this is repeated. So now this is original jurisdiction. So what does original mean? Okay, original jurisdiction of Supreme Court, a very important topic. So again, when you refer to the previous year question papers, so few questions have appeared on this topic. Okay, few questions have appeared. So disputes between center and state. So whenever there is a dispute between center and state, so that dispute has to be resolved, right? So who has the power to resolve? Supreme Court. Okay, Supreme Court. So can you give me an example of a dispute that can arise between center and state? Yes. Water, generally it will arise between multiple states. Okay. Yes. Border. Okay, border region also it will arise between states. Subjects. Okay, subjects related matter can come for a dispute. For example, center can make a law on state is subject like health. Now states are not satisfied. Some states says that you are infringing our powers. At that time, such cases can be taken to Supreme Court. Yes, you give one more example. Grants. So grants again we are not sure, but taxes we can say. So taxes related to some cases, center and state. So state can file a case against the center, okay, in the Supreme Court. So such cases are heard by Supreme Court. So here it is called as original jurisdiction and exclusive jurisdiction. So both of them they have a different meaning. Original means it should hear first, means the case cannot go first to High Court and then come through an appeal. Original means only directly it should hear. Okay, it should hear. Exclusive means only Supreme Court itself can hear. High Court cannot hear. Okay, cannot hear. Now next when we start discussing about writ, we come across only original jurisdiction, not exclusive. Okay. So here exclusive means when it comes to center state disputes, only Supreme Court can hear, and also it cannot come through an appeal. It cannot come through an appeal, only directly first instance itself it should hear the cases. It should hear the cases. Next, between center and state on one side and states on the other. So in the first example, for example, central government and Karnataka state government. So this is the first example. So second example can be, for example, center and Karnataka, they are fighting on one side and Tamil Nadu is fighting on the other side. Okay. So center and state on one side and state on the other. Two or more states, for example, Karnataka and Maharashtra. So they have a dispute. So these disputes can also be handled only by Supreme Court. So in the examination, what kind of questions can be framed? So dispute between two or more states can be handled by High Court. True or false? False. Why? Because it is exclusive. Okay, it is exclusive. So fundamental writs can be heard only by Supreme Court. False. Because it is original but not exclusive. Okay, not exclusive. So two or more states. Exclusive means no other court can decide. Original means not by way of appeal. Okay, not by way of appeal. So what kind of things it can hear? Question of law or fact. Existence or extent of legal right depends. So this statement will cause you confusion even while going through the book. So you just ignore this statement. Don't focus on this statement. Okay, just don't focus on this statement. So they are not going to go to such a deeper level and check whether you have complete depth understanding or not. Please ignore this statement. Okay. So it will hear cases related to law or fact. If you want to memorize, just memorize these two terms. It can hear cases related to either law or fact. What is law? What is fact? Don't worry about it. Don't worry about it. So it cannot hear political nature questions. Okay, it cannot hear political nature questions. So what exactly is the political nature? Can you give an example of a political nature question? Okay, it will be difficult to connect. Dissolution, okay, not dissolution. So for example, let's assume he mentioned the example for grants. So someone will complain that ours is a BJP ruled state and at the center we have Congress. So they are giving less funds to us and they are giving more funds to other state. So there is no solid base for it. You are just making an allegation because it's of political nature. So at the center lies the Congress and at the state lies the BJP. So I am just giving an example, again not important. So maximum what they can focus is whether political nature questions come under the exclusive original jurisdiction of the Supreme Court? No. Okay, no. Private citizen suit against center or state, not covered under it. So private citizen suit, for example, if the road is not being constructed properly, so this is a responsibility of state government. So someone, if he files a case against the state government in the Supreme Court, he cannot file it, it does not come under the original jurisdiction. So can he file a case? Yes, he can file a case, but it does not come under the exclusive original jurisdiction of Supreme Court. Okay. So such cases can be heard by appeal, later on we will be looking into it. So from exam point of view, so whether private citizen suit against center or state, whether it falls under exclusive original jurisdiction of Supreme Court? No. Okay, no. Next, this exclusive original jurisdiction of Supreme Court does not extend to pre-constitutional treaty. Okay, pre-constitutional treaty. For example, we got a constitution in 1950, but before 1950 also there were some kind of understanding or treaties that were reached. For example, let's assume before our constitution there was a state called as Madras, there was a state called as Mysore before independence or before we got the constitution. So let's take the example of Kaveri river itself. Okay, Kaveri river itself. So let us assume Mysuru and Madras state before independence itself, they had an agreement that so and so quantity of water should be supplied to Madras region through Kaveri river. Okay, through Kaveri river. So this is a treaty which existed before the constitution came into force. So when someone will file a case in the Supreme Court saying that this treaty is wrong, I want to correct this treaty. So such cases will not fall under the exclusive original jurisdiction of the Supreme Court. Very important. So pre-constitutional treaty, they do not fall under the exclusive original jurisdiction of the Supreme Court. So treaty explicitly excludes its jurisdiction. Okay. So now after independence also there are some treaties between two states, but in the treaty explicitly they will say that the Supreme Court should not hear such kind of cases. Such cases can also not be taken by Supreme Court. Okay. Interstate water disputes. So here I took an example of interstate water disputes, but the treaty may not be exactly for the interstate water disputes. It can be for other purposes as well. Okay, other purposes as well. So again, interstate water disputes, Supreme Court's exclusive original jurisdiction does not extend to interstate water disputes. So while discussing center-state relations, if you remember, okay, so we discussed that water is a very sensitive subject. So can Supreme Court give a judgment on water-related issues? No. So Constitution has given more power to whom when it comes to interstate water disputes? It has given more power to Parliament. And Parliament, by using that power, it has passed multiple acts, enacted multiple laws. Which are they? Interstate Water Disputes Act and next River Boards Act. Okay, River Boards Act. So similarly here, the same we are again recollecting. So interstate water disputes, they do not come under the exclusive original jurisdiction of the Supreme Court. Matters referred to, FC means Finance Commission. So already President has given a matter to Finance Commission. So you work on that. So someone cannot challenge in the court that whatever the matter that has been referred to Finance Commission is not correct, it has to be changed. No. Such cases do not come under the exclusive original jurisdiction of the Supreme Court. Adjustments, expenses and pensions of center and the states. Okay. So again, not important point. Expenses and pensions related to center and states, not important. Ordinary dispute of commercial nature, center and state. Okay. Ordinary dispute of commercial nature, again, let's take a very, very simple example. Now let's assume a central government property exists in Karnataka. Okay, Karnataka. So now let's assume Karnataka government is occupying that, the building which is present in front of our building, let's assume it is central government building. Now Karnataka government has taken it for rent. Now but it is not paying the rent on monthly basis to the central government. So this is what? Ordinary dispute of commercial nature. I just took an example. So such cases Supreme Court cannot take under the exclusive original jurisdiction. Okay. Again, we need to understand the exam's demand also. When you look at the previous question papers, repeatedly it focuses on center and state. Okay, between multiple states. So very rarely it comes across such kind of points. So from the exam point of view, these points do not carry much weightage, especially from prelims point of view. Okay, that exam's demand is also equally important. Recover of damages by a state against center. Okay, so again one example. For example, railway belongs to whom? Central government. So let's assume a railway which is traversing through Karnataka. So there will be an accident. So because of the accident, not only the railway station property will get damaged, the surrounding area, the private property also will get damaged. Okay. Now the residents of Karnataka, they will start claiming against the state government that we want that compensation. Now that compensation state government will give, but it has to take from whom? From the central government. So recover of damages by state against center. Again, such cases, it cannot, if the center is not paying the compensation for the damages, then we have to file a case. So where we will file the cases? Okay, so directly Supreme Court or not. Again, such cases, they do not come under the exclusive original jurisdiction of the Supreme Court. Okay, Supreme Court. So first such suit in 1961 by West Bengal government against the center. So whether such a case have ever been filed against the center? Yes. So first such case was filed against the center in 1961 by West Bengal government. Okay, West Bengal government. So the examination they may ask in the worst case, so whether in the history of India, whether any cases have been heard by the Supreme Court under its exclusive original jurisdiction. So next is writ jurisdiction of Supreme Court. So here we saw that jurisdiction means Supreme Court can hear the cases with respect to the dispute between the center and the state, center and state on one side and state on other side. Next, center between states. How about the dispute between the center and the union territories? So this is how the UPSC will focus. The information which is missing here, it will focus a question on that. Who handles a dispute between the center and the union territories? Yes. So a dispute will never arise between the center and the union territories because union territories are directly under the control of the central government. So a dispute between the center and the union territories, it does not fall under the exclusive original jurisdiction of the Supreme Court. Okay, we have to understand. Next, writ jurisdiction of Supreme Court. Okay, writ jurisdiction of Supreme Court. So whenever we say writ, it means we are speaking about fundamental rights or violation of fundamental rights. Okay. So Supreme Court is a guarantor and defender of fundamental rights of citizens. Okay. So don't try to find the exact meaning between the difference between guarantor and defender. Just memorize this thing. It's a guarantor as well as defender of fundamental rights of the citizens. Empowered to issue. So I think we have discussed about the habeas corpus and all during the discussion of fundamental rights. Okay. Habeas corpus, mandamus, prohibition, quo warranto, certiorari. Okay. If there is confusion, I will urge you to go back to the fundamental rights related class to understand in detail about what are these habeas corpus and other writs. So why these writs are issued? To enforce the fundamental rights of the aggrieved citizen, the person who has faced a problem. So he will go and approach the Supreme Court. By hearing his case, Supreme Court will issue various writs. So it may be a habeas corpus, it may be mandamus, or so on. And so on. It is original jurisdiction and not exclusive. This is important. Supposedly writ jurisdiction, if it was exclusive, suppose the writ jurisdiction was exclusive, then what would have happened? Whenever a fundamental right got violated, then what were the chances? Where you should have gone? Directly Supreme Court. There were no chances of you going to High Court. Suppose the writ jurisdiction was exclusive. But now the writ jurisdiction is not exclusive. Okay, it's not exclusive. But it is original. What does it mean? Whenever your fundamental right has been violated, you can either directly go to Supreme Court or High Court. Okay. You cannot come by via appeal to Supreme Court. When a fundamental rights gets violated, you should go to High Court. If the decision given by the High Court, if you are not satisfied, can you go by appeal to Supreme Court? No, because it's original. Supreme Court should hear it at the first instance, not through way of appeal. Okay, very important. So that is the meaning of original. Okay, original. So these things are very, very confusing. Okay, very confusing. Original means Supreme Court will hear it at the first instance, not by way of appeal. Cannot by way of appeal. So why it is not exclusive? Because High Courts in India are also empowered to issue these writs. Already we have seen. Okay. So it means aggrieved can move either Supreme Court or High Court. The person who is facing the problem, he can move to Supreme Court or he can move to High Court, and if he is not satisfied with the judgment of the High Court, then he can appeal to Supreme Court. Yes or no? No. He cannot appeal when it comes to writs from High Court to Supreme Court. High Court can issue writs for other purposes as well. This is also important. I think during the discussion of fundamental rights, whether we came across this point or not, but this is very important. Now, Supreme Court can also issue writs for the violation of the fundamental rights. High Court can also issue writs for the violation of the fundamental rights. Now, apart from the fundamental rights, if any of your other right gets violated, for example, right to property. Let's take right to property. So, during the discussion of fundamental rights, we saw that right to property is a fundamental right. Yes or no? Originally, it was a fundamental right. Yes, it was removed from the list of fundamental rights. Now, can we consider right to property as other purpose or other right? Yes. When your right to property gets violated, can you directly go and file a case in Supreme Court under writ jurisdiction? No, because Supreme Court can only hear writs with respect to the violation of the fundamental rights. Okay, with respect to the violation of the fundamental rights. But can you go and file a case in the High Court saying that your right to property has been violated? Yes, because High Court can issue writs for other purposes as well. Apart from the violation of the fundamental rights, it can also issue writs for the other purposes as well. Okay, other purposes as well. Hence, writ jurisdiction of High Court is wider than that of Supreme Court. Very important. Now, this statement, when they make in the examination, if we do not have the depth of understanding, we often end up marking a wrong choice. So, we come to a conclusion that this statement is wrong. But here, we have to understand that Supreme Court has more powers in all the other aspects. But when it comes to writ jurisdiction, so whose jurisdiction is wider? High Court's writ jurisdiction is wider than that of the Supreme Court. Okay, Supreme. Parliament can confer on the Supreme Court the power to issue other writs as well. Again, this is also important. So now, High Courts have the power to issue writs with respect to other issues. Similarly, can Supreme Court also issue? Yes, they can issue, but that power has to be conferred, has to be given to Parliament. By whom? Sorry, to Supreme Court. Who will give the power? Parliament. Okay, Parliament. Now again, don't go to the detailed aspect whether Parliament has ever given such kind of power or not, whether it has passed any act or not. No. Okay, just we understood that Parliament can give what powers to Supreme Court to issue writs with respect to other matters as well. So, but for High Court, it is by default. By default, it can issue writs for other purposes. Okay, other purposes. Now we saw two jurisdiction. One is original jurisdiction, another one is writ jurisdiction. So these two aspects are very important from exam point of view. The next jurisdiction, that is appellate jurisdiction of Supreme Court, it's not that much important. Okay, they have given so much of content in the book. So every line, sometimes it starts appearing important and sometimes it starts causing confusion. So many times aspirants will be stuck there itself. You will not get stuck there itself. If you are not understanding few of the things, even when you go back, you will not pause there itself. You will just proceed to the next point. That is very important. Okay, because we have to complete all the syllabus, right? So everything which is important from the exam point of view, it should be at the tip of our finger. Okay? Hence, it's very important to ignore the unnecessary things. So appellate jurisdiction of Supreme Court. So appellate means it will hear the cases by way of appeal. So whatever the judgment the High Court has given, so if a person is not satisfied, he will go to Supreme Court. So such cases or such hearing is called as appellate jurisdiction. Okay, appellate jurisdiction. Supreme Court has succeeded the Federal Court of India. So already we have seen during the introduction. So Federal Court of India was established through which act? 1935. Next, it was replaced by Supreme Court in which year? 1950. Next, we also saw that Supreme Court has replaced the British Privy Council as well. So previously, British Privy Council was the highest court of appeal, but now Supreme Court is the highest court of appeal. Okay, Classification. When it comes to appeals, it can hear different types of cases. It can hear constitutional matters. It can hear civil matters. It can hear criminal matters. Okay, criminal matters. So let's take one example for each just to understand at the superficial level. So constitutional matters. So let's assume Centre has brought an act called as Agriculture Reforms Act 2025. Agriculture Reforms Act 2025. It has been brought by central government. Okay, Parliament has brought this law. Now this agriculture is an issue which belongs to which government? State government. So centre ideally should not make this law. Now some states are not happy. Let's assume a person in Karnataka, he will challenge this law. Where? In Karnataka High Court. Can a law enacted by the central government be challenged in the Karnataka High Court? Yes or no? Yes, because India's judiciary is federal or integrated? Integrated. We have seen they can enforce both central laws as well as state laws. So this is the law made by Parliament, that is center, but now a Karnataka person has challenged this law in the Karnataka High Court, saying that this law, it violates the constitution. Why it violates the constitution? Because it violates the federal structure. Agriculture is a stateless subject, so state should have made the law, but center is making the law. Okay, center is making the law. Now Karnataka High Court, what it will do? It will declare this law as invalid. Invalid and void. Can Karnataka High Court do this? Does Karnataka High Court has the power? Yes, it can declare it. Now what the central government will do? It will appeal this judgment. It will appeal this judgment in Supreme Court. The Supreme Court. So now it is called as appeal in constitutional matters. Now again questions will arise. What is the questions? Already we have seen center state dispute, it comes under original jurisdiction. Here it is appellate. What is the difference? We will not go into these exact differences. Now the difference is not between the center and the state. A private person has filed a case against the center saying that it violates what? This law, it violates the constitution, federal structure. So it is not a dispute between center and state. And even if you are not able to connect to such a deeper extent, also just leave it. Okay. So what we have to understand here is Supreme Court's appellate jurisdiction includes appeals in constitutional matters. So this is an example of a constitutional matter. I am just giving an example. Okay. Again, there may be some other examples as well, just to connect and to help us comprehend the things easily. Next, civil and criminal. Okay. Civil and criminal. Okay. So let's assume property related, just at a superficial level. So we will not go like a lawyer into deeper aspects of exact difference between civil and criminal. So civil matter we shall take property related matter, and criminal matter, let's say murder. Murder we shall take it as an example. So let's assume someone has, person 1 has forcefully taken the property of person 2, okay, by creating some documents and all. Okay, documents and all. So this case will go to High Court. High Court. Now High Court will rule in favor of person 2. So it will say person 2 is correct and it belongs to him. Now what person 1 will do? He will appeal this judgment in Supreme Court. So that is the appeal in case of civil matters. Okay, civil matters. Similarly, when it comes to criminal matters, let's assume person 1 has murdered someone. Okay, murdered, or there is an allegation that he has murdered. Okay, he has murdered. Now this case will go to High Court. High Court will declare that yes, he has committed mistake, let us give him 20 years jail or 20 years imprisonment. Okay. So this is a criminal matter. Now this person 1, he will challenge it in Supreme Court. So now Supreme Court will hear this case. This is called as hearing the appeal in case of criminal matters. Okay, criminal matters. Next, appeals by special leave. Now whenever High Court gives a decision, it will say that it will produce one more letter saying that if you are not satisfied with our decision, you can appeal it to next court. Okay, next court. But sometimes High Court will not issue this letter. Okay, not issue this letter. So Supreme Court will issue a letter. We are giving a special leave. Whatever cases you have, you can file, you can appeal to us. Okay, appeal to us. This is called appeal by special leave. Again, we will be discussing about it later on. Okay. So here, what we understood here is when it comes to appellate jurisdiction exists in case of constitutional matters. Appellate jurisdiction exists in case of civil matters as well as criminal matters. So constitutional matters already we discussed with the help of an example. So against judgment of High Court, if the High Court certifies that the case involves a substantial question of law that requires interpretation of constitution. So again, this line by line information is not important. So after giving a judgment, we took an example of which act? Agriculture Reforms Act. So Agriculture Reforms Act 2025. So High Court will give a judgment on it, and it will say that it also give a certificate saying that we have given the judgment, but the case involves substantial question of law that requires interpretation of constitution. So this case involves interpretation of constitution. Hence, a person who wants to file an appeal, he can file in the Supreme Court as well. But this statement is not important. You need not focus on it. Okay, need not focus on it. So from any judgment of High Court, if High Court certifies, okay. Now here, you don't go into these points itself, because again understanding exams demand is important. Unnecessarily they'll cause you confusion, not important. You have to become jack of all the subjects. Okay. So what you have to understand here is, Supreme Court can hear appeals from any judgment of the High Court if High Court certifies. High Court has to certify. What it has to certify, they are given here, not important. Question of law or general importance, these things will cause a lot of confusion. Again, not important from exam point of view, you just ignore these points. Okay. Question of law or general importance, you just ignore that point. Criminal matters. Okay. So criminal matters, he has given too much of information. We will now discuss, but at the time of examination, we will not go into these detailed aspects. Okay, we have to understand the exam's demand. So criminal matters, if a High Court on appeal reversed acquittal to death, matter of right, no certificate required. So again, to such a deeper level, they have never asked. Okay, they have never asked, but at least we should try to understand what does it mean. So let's assume a district court, High Court, Supreme Court. Okay, district court, High Court and Supreme Court. So person involved in murder, allegations of murder. So what is allegation? What is allegation? It means whatever the charges are there, they are not yet proved. You have just made an allegation. You have just made an allegation. Now the police force has to prove it. Okay, has to prove it in the court of law. So allegations of murder. So that case will go to district court. So in district court, what they will come to a decision is, so let's assume person A and he has killed person B. Okay, so he has killed him or he has murdered person B. Now person A has been acquitted. Person A has been acquitted. So the meaning of acquitted means he has not committed any murder, there are no proofs, so he can go back to his home. He can relax. That is called as acquittal. So in the newspaper regularly when you are reading, so you come across these terms, acquittal. Acquittal means the charges are not proved. He is innocent. He will be sent back. Okay. So no punishment. But when this person is acquitted, whether the family members of B will keep quiet? If they really have a concern for person B, then what they will do? They will go for an appeal to High Court. What they will say? The district court has said that this person has not committed any murder and it has acquitted it, but we are not satisfied. We are coming in the form of appeal to you. Now High Court, what it will do? Again, it will call all the documents. Again, by cross-checking and all, it will give a judgment that this person has committed the murder and he will award him death sentence. He has to be hanged till death. So see here, it's completely reverse. The district court has said free, acquittal, but High Court, death. So here, on acquittal to death, so on appeal reversed. So who got the appeal? High Court got the appeal. On getting appeal, it reversed the acquittal to death. The person who was free, now he has been given the death sentence. So now whether this can be filed, again appeal can go to Supreme Court. Now in this, who will go as an appeal to Supreme Court? Person A or the family members of B? Yes. Because already now he has been given death sentence, the family members of B are celebrating. Right? So who will go to Supreme Court? Person A will go to Supreme Court. Okay, person go to Supreme Court. Now in the previous case we saw that whenever High Court gives a decision, it has to give a certificate that if you want you can appeal to the Supreme Court. Okay. Now in this case, let's assume High Court refuses to give that certificate. It is not right to give that certificate. Can person A appeal in the Supreme Court or not? Yes. Now here it is, no certificate required. It's a matter of right. It's a matter of right. So High Court, after receiving an appeal from the lower court, if it has reversed the judgment from acquittal to death, then that cases can be appealed to Supreme Court without the certificate of the High Court also. Okay, High Court also. Next, taken itself from subordinate court, awarded death sentence, matter of right, no certificate received. The second case is, the district court is still hearing the case of this person A. District court has not yet given the final judgment. In the previous instance what we saw, district court has already given the final judgment. Now the second instance is, let's assume district court has not yet given the final judgment, still it is hearing the case. In such a scenario, High Court what it will do, it will take the case by itself. The High Court has the power. Okay, it will take the case by itself, and after taking the case, it will award a death sentence to person A. Okay, to person A. In such a scenario also, as a matter of right, person A can appeal to where? Supreme Court. Here also note certificate is here. Okay. These are two cases. Third case is High Court certifies that the case is fit for appeal. So irrespective of any case, if the High Court says that, it will produce a certificate saying that this case can be appealed to Supreme Court, then we can appeal. So in the previous two instances, no certificate was required. So here, if a certificate is provided, then also in any case they can appeal. Okay, they can appeal. On appeal, reversed death to acquittal. No right to appeal. Okay, what does it mean? The same case, High Court, District Court, Supreme Court. So District Court has given death sentence to person A. Okay, death sentence to A. Next, High Court has reversed death sentence to acquittal. Now you are free. In that case, who will go to Supreme Court? Now person A will not go to Supreme Court, probably the family members of B will go, but that no right to appeal. No right to appeal, so it means they should be given a certificate. The family members of B should be given a certificate. Then itself they can appeal. Okay, they can appeal. Criminal appellate jurisdiction enlarged by Parliament in 1970. So in 1970, they have made some changes. What are the changes? Reverse acquittal to life imprisonment or 10 years. So previously we saw reverse the judgment from acquittal to death, but now not death. Death is replaced by life imprisonment or 10 years. So if a person who was set free by the district court, now if he is given life imprisonment by High Court, then such cases can also be appealed. Okay, has taken before itself a sentence, again same content, not important. So what you can do is you can ignore this content. Now whatever we discussed here, okay, just to make just to help us understand the things I have discussed, but from exam point of view, they are not going to delve to such a deeper extent. That we have to understand. Okay, that we have to understand. Some things that you have to understand, that is, so what is certificate? So whether in all the appeals certificate is required or not. So in this fashion, superficial level aspects are important. Okay? Aspects are important. Appeal by special leave. Okay, so here special leave indicates. So this appeal by special leave, whether it's a power of Supreme Court or High Court, it is Supreme Court discretion. Okay, Supreme Court discretion to grant special leave. So as I mentioned, in some cases High Court should give judgment, will give judgment. After that, it should also issue a certificate saying that you can appeal to Supreme Court. But if High Court is not ready to issue this certificate, but still person A, he wants to appeal to Supreme Court, then to address such kind of rare cases, so Supreme Court can grant a special leave to person A. Okay, person A. So that is special leave. Any matter passed by any court or tribunal except military court and court martial. So this appeal by special leave is not applicable to military court and court martial. Not applicable to. So it is discretionary, not claimed as a right. So no one can go and approach the Supreme Court that you have to give me, it is a right. No, it is discretion of Supreme Court. Means Supreme Court may use this power or it may not use this power, not exercise the power. So any judgment final or interlocutory. So it means even the case is being heard by High Court. So it is not necessary that Supreme Court will issue a special leave only after the final judgment. Even when the case is going on, at that time itself it can take this case by special leave. The special leave. Any matter against any court, not necessarily High Court. So when it comes to special leave, so it is not that only the cases of High Court will come to Supreme Court. Even if the case is going on in the district court also, that case can be taken by the Supreme Court. So this is appeal by special leave. Okay, special leave. So we discussed about three jurisdictions. One is exclusive original jurisdiction of Supreme Court. Then we discussed about the writ jurisdiction of Supreme Court, and then appellate jurisdiction of Supreme Court. Okay. So next, apart from that, we also have advisory jurisdiction of Supreme Court. Okay, advisory jurisdiction of Supreme Court. So here, whenever President is under confusion, so when I say President, it is Government of India. That is central government, that is Council of Ministers headed by Prime Minister. But we will not use the term called as government, I will use the term only called as President because it has been explicitly mentioned here. So President will seek the opinion of Supreme Court. On some matter, he will seek opinion of Supreme Court. So Supreme Court will, it may give opinion or may not give. President seeks opinion from Supreme Court. Supreme Court may give opinion or it may not give opinion. Again, it is dependent on cases. In which case it should give opinion, and in which case it is not necessary for Supreme Court to give opinion. So here we have two cases. Okay, one is question of law or fact of public importance. Another is dispute arising out of pre-constitutional treaty. Okay, pre-constitutional treaty. So here keyword is pre-constitutional treaty. Question of law or fact of public importance. Now this term will cause confusion. Okay, question of law or fact of public importance. So let's take an example of a fact of public importance. Okay, for example, let's assume somewhere there is a communal violence in a great way. Okay, in a big way there is a communal violence. So now President wants to decide whether he has to impose national emergency or not. I am just giving an example, this is not exactly how it works. So President is under a dilemma. So what President will do, so it's a question of law or it's a fact of public importance. I am just taking an example. So in the examination, if you are getting confused, you please memorize these terms. Question of fact or public importance. Okay, public importance. So now he will seek opinion from Supreme Court. Another one is pre-constitutional treaty. So President is confused about the treaty which has taken place before independence. Let's assume 1920 Indus Water Treaty. In which year Indus Water Treaty came into force? 1956. Yes, okay. We shall take some imaginary treaty. 1920 Karnataka Tamil Nadu Treaty Agreement. So President is confused about this thing as well. So in both the cases, first case is question of law or fact of public importance. Second is dispute arising out of pre-constitutional treaty. So in the first case, Supreme Court may tender or refuse. What does it mean? Supreme Court may say, it may give opinion, or it may say I am not ready to give opinion. Okay, even if the Supreme Court says I am not ready to give opinion also, it is okay. Okay, it is okay. But when it comes to dispute arising out of pre-constitutional treaty, Supreme Court must give its opinion. This is very important. Okay. So what we saw, President will seek opinion from Supreme Court in two cases. One is question of law or fact of public importance. Next, dispute arising out of pre-constitutional treaty. In which these two cases, Supreme Court has to compulsorily give its opinion? Pre-constitutional treaty. In case of question of law or fact of public importance, it may give or it may not give. Okay, it may not give. Let's assume Supreme Court has given the opinion. Okay, opinion in either first case or second case. In which case it is binding on President and in which case it is not binding on President? Yes. Not binding on President. Okay. In both the cases, whatever the advice the Supreme Court gives to President will listen, but it is not necessary that he has to follow according to it. It means it is not binding on President. So this is called as advisory jurisdiction of Supreme Court. Okay. So facilitates the government to have an authoritative legal opinion on a matter. So on some matter when government wants an exact authoritative reply, then it will ask the Supreme Court. Okay. Not important from exam point of view. So whether in the history of India such references have ever been made by the President to Supreme Court? Yes, example of such references made exist. So in the book they have mentioned about few examples in which all cases President has made a reference to Supreme Court. So those examples are not important from exam point of view. What is important here is in the history of India whether ever President has made a reference to Supreme Court or not. Okay, sought opinion from the Supreme Court or not? Yes, he has sought. Next, Supreme Court as a court of record, a very important point here, because the majority of the aspirants, by the time they come to this page of the Lakshmikant, so they will be exhausted. So from this page onwards, generally they'll skip. But UPSC will focus a question from these pages. So again, very important. Okay. So we have already seen a concept called as judicial review, right? So judicial review, it exists in which part of the Constitution? It is not explicitly present in any of the articles of the Constitution. But which article provides for the judicial review? 13. Article number 13. Okay. So while discussing this, we will come across similar such provision called as reviewing its own judgment. Reviewing its own judgment, so it will cause confusion, hence I mentioned it earlier. So Supreme Court has two powers. So Supreme Court as a court of record, it has two powers. What is that? Judgments etc. are recorded for perpetual memory and testimony, are admitted to be of evidentiary value, cannot be questioned when produced before any court, recognized as legal precedents and legal references. Okay. So this line by line is not important. What we have to understand here is, now generally you might have seen in some films and all, so whenever in high court one lawyer is arguing in front of, handling the case in front of the judge, he'll quote the judgments of Supreme Court. So in high court, if let's assume some case is going on, the lawyer will say, so recently Supreme Court has given so and so judgment in such a case. Okay, he'll refer it. So when such references are made, no one can question it. For example, let's assume in Karnataka High Court, so a lawyer is arguing. Let's assume Ravichandra is arguing. So Ravichandra is quoting. What is quoting? So in the Supreme Court in 1985, there was a judgment. Okay, there was a judgment. So in that judgment, they have given a judgment like this. So he'll quote it. So when he will quote that judgment to High Court, he will request, you also please consider that case into account and give a similar kind of judgment. Now the judge of the High Court, he cannot say that Supreme Court might have said in 1985, but I am a judge of Karnataka High Court, I am not going to listen to the words of Supreme Court. Can he say that? No. Because once the Supreme Court gives the judgment, so it will be recorded for perpetual memory. Okay, and it will act as testimony, and it can be admitted in any court of law, whether it is High Court or whether it is District Court or Taluk Court, anyone can quote it. So that is the meaning of court of record. This line by line information is not important. Okay, not important. So one is, it is act as a perpetual memory, that is court of record. So another meaning is to punish for contempt of court. So by using the power of a court of record, it can be used as evidentiary value. It's of evidentiary value in any court. The second one is using a court of record power. Supreme Court has the power to punish for contempt of court. So if anyone, so again when it comes to contempt, there are two types of contempt. Fully discussed here. Okay, here we have. Okay. There are two types of contempt. One is civil contempt, another one is criminal contempt. Willful disobedience to any judgment, order, writ or willful breach of an undertaking given to a court. So Supreme Court will give a judgment saying that recently you have caused an accident. So person A, you have caused an accident and you have damaged some of the properties of person B. So you have to pay 1 lakh rupees to person B. So this is a judgment given by Supreme Court. Now this person A, they will give a deadline within what? Within October 30. But this person will not pay within October 30. It means he is not following the instructions of the Supreme Court. When he is not following the instructions of the directions of the Supreme Court, it means he is involved in a contempt. Contempt of what? Supreme Court. What kind of contempt? Civil contempt. So willful disobedience. So accidentally he might have forgotten, or probably he might have met in accident and he might be in hospital, that is different. But willful means deliberately, intentionally he has not given the damage charges to person B. So this is called as what? Willful disobedience. It is an example of civil contempt. Okay, civil contempt. Criminal contempt. Publication of any matter or doing an act which scandalizes or lowers the authority of a court, prejudices or interferes with the due course of a judicial proceeding, interferes or obstructs the administration of justice in any other matter. Okay. However, innocent publication and fair criticism does not amount to contempt of court. So this is the opposite of that. Now Supreme Court will give a judgment. Let's assume judgment on article number 370, judgment on GST. Now someone will write an article in the newspaper saying that whatever the judgment the Supreme Court has given with respect to article number 370, it's not correct. Supreme Court is not functioning correctly. So here, this is criticism of the Supreme Court. Now someone will make a video of the Supreme Court criticism and he will upload it in the YouTube. Again, those all examples are what? Contempt of court. But what kind of contempt? Criminal contempt. There, not following the Supreme Court orders is civil contempt. So criticizing the Supreme Court is criminal contempt. Okay, criminal contempt. So again, this line by line information is not important. Just with one example, you try to retain the content. So Supreme Court has the power to punish for contempt of court. So one important thing that we have to remember here is contempt not only of itself. If someone criticizes the judgment of Supreme Court, obviously Supreme Court will punish them under contempt of court. But here, under this power of court of record, it can punish for contempt of High Court. For example, someone criticizes the judgment of High Court. For that also, he can be punished by whom? Supreme Court. Subordinate courts. So later on we will be discussing about subordinate courts like district court and all. If someone criticizes the judgment of district court, can Supreme Court punish such person under contempt of court? Yes. Again, tribunals. Okay, we will be discussing about tribunals as well. It means under Supreme Court's contempt of court, it will not only punish for the contempt of itself, but the contempt of the High Court, the contempt of the subordinate court, tribunals as well. Okay, as well. And it extends to both civil contempt as well as criminal contempt. Okay, criminal contempt. So Supreme Court's power of judicial review. Okay. Next is power of judicial review. Already we have seen about the judicial review. Okay, judicial review. So what is judicial review? Power to examine the constitutional validity of the legislative enactments and executive orders. So first thing that we have to understand here is judicial review power, whether it extends only to legislative enactments or also it extends to executive orders as well. So if I say legislative enactment, can you give an example? Any laws can be called as legislative enactments. So what is the executive order? Implementation? Yes, implementation can be an example of executive order. For example, now Home Minister will give a direction. What is that? So police force, you become very strict in Karnataka, or he'll give an instruction to CBI. So handle all the cases only related to Karnataka because Congress government is there in Karnataka. Whereas in Maharashtra, you don't touch any of the cases because the state is being ruled by BJP. So this is what? This is an executive order. This is not a law. Now, can someone challenge this executive order in the Supreme Court saying that it is violating the Constitution? Yes, because the Constitution says that right to equality. So it is being violated. So even this executive order can be challenged in Supreme Court. Similarly, a law can be challenged in Supreme Court. So under power of judicial review, so the Supreme Court can examine the constitutional validity of both legislative enactment as well as executive order. Of whom? Of both central government as well as state governments. Not only of central government, both central as well as state government. Okay, state government. If found to be violative of the Constitution, Supreme Court, after studying the legislative enactment or after studying the executive order, if it finds that it is violating the Constitution, it is not as per the provisions of the Constitution, then what we can do? Such a law or such an executive order can be declared as illegal, unconstitutional and invalid, okay, by Supreme Court. By Supreme Court. So consequently, once such a law has been declared as invalid, once such an executive order has been declared as invalid, it cannot be enforced by government. After the Supreme Court declaring it as invalid, so government cannot go forward and start implementing that law or start implementing that executive order. Okay, executive order. So why is this requirement of judicial review? To uphold the principle of supremacy of the Constitution. So who is supreme in India? People of India or Constitution? Yes. to uphold the principle of supremacy of the constitution, to maintain federal equilibrium. So how federal equilibrium will be maintained? We have seen, if center tries to make a law on the stateless subject, so it will become a threat to federalism. So to stop such kind of threats, so Supreme Court can use the power of judicial review. If center makes a law on the stateless subject, then Supreme Court will go for judicial review. So saying that the law made by you is not adhering to the constitution. Why it is not adhering? Because you are making a law on a subject which belongs to state list. Okay, state list. To protect fundamental rights of citizens. So we also require the power of judicial review to uphold the fundamental rights. Okay, to uphold the fundamental rights. If a law made by Parliament, if it violates any of the fundamental rights, then such a law will be declared as invalid by Supreme Court. In this fashion, it will uphold or protect the fundamental rights of the citizens. So whether Supreme Court has used the power of judicial review? Yes, it has used the power of judicial review in multiple cases. So just two I have quoted here: Golaknath case and Keshwanand Bharati case. Okay, Keshwanand Bharati case. Judicial review phrase, though nowhere used in the constitution. Okay, it is nowhere used in the constitution. The provisions of several articles explicitly confer the power of judicial review on the Supreme Court. If you read the various articles of the constitution, you will get to know that there exists a power of judicial review on the Supreme Court. Okay, with the Supreme Court. Constitutional validity can be challenged on three grounds. So whether any law or executive order, whether it is violating the constitution or not, how you will get to know? First, if you will check whether the law takes away the fundamental rights. Infringes means takes away the fundamental rights. If a law or executive order, if it takes away the fundamental rights, then we can say that the constitutional validity is being failed by a particular law or executive order. If it is outside the competence of the authority, for example, if center makes a law on the stateless subject, repugnant to the constitutional provisions, generic, just leave it. Just leave it. Scope of judicial review in India. Scope of judicial review in India. So here there are some things which are very confusing. So in one go you may not be able to connect all the dots. So gradually again we will be discussing one by one. So scope of judicial review in India is narrower than that of what exists in USA. It means the judicial review scope is wider in India or USA? USA it is wider. So how is it wider? We shall look into it. American Constitution does not explicitly mention about it. American Constitution also explicitly does not mention about the term judicial review. Again, question can be framed in prelims. How they can frame a question? The term judicial review is explicitly mentioned in the American Constitution, whereas it is not in the Indian Constitution. True or false? False. In both Indian Constitution as well as American Constitution, there is no explicit mention of the term called as judicial review. Okay, judicial review. But the scope of judicial review is more in which country? USA. Okay, America. American Constitution provides for due process of law. So this is very important. I think during the discussion of fundamental rights also somewhere we came across this term, due process of law and procedure established by law, probably while discussing article number 21. Okay, so I urge you to go back to that class related video once again to connect these two dots. So due process of law gives wide scope to Supreme Court to grant protection to the rights of its citizens. Declare violative not only on substantive grounds of being unlawful, but also on procedural grounds of being unreasonable. Okay, while discussing about article number 21, we have discussed. So what does it mean? Due process of law. So in India, what is the job of the courts? Just to study that whether the law is being followed properly or not. Okay, in case what happens is, we shall take an example. So Labour Act 2025. Labour Act 2025. So in Labour Act there are, let's assume there are various sections, section 1, section 2, section 3 and so on. Somewhere we have section 50. So section 50 says that a person can be employed for 12 hours a day. Let's take not 12, 15 hours a day. So there are 24 hours. In that 24 hours he can be made to work 15 hours a day. So this is Labor Act of 2025. Now a person working in a factory, let's assume person A, and this factory name is, let's assume company X. So company X, it owns a factory, so this company X, so there a person is working called as A. Now he is being made to work for 17 hours a day. Now this person or someone on behalf of person A, they will go and file a case in the court. Okay, they will file a case in the court, let's assume Supreme Court. Now Supreme Court will study, so whether he is being made to work for 17 hours, so by various cameras and all that video footage, they will come to know that he is working 17 hours a day. Now what the Supreme Court will do, it will study this law. So in this law, what has been written? 15 hours a day. So he is being made to work 17 hours a day. It means company X is violating which law? Labor Act 2025. So this company will be given a punishment. It may be in terms of what? Fine or something. Fine, or it may even give a jail sentence to its CEO. Okay, to its CEO. Now what the court is doing? It is following the procedure. Now let's assume another person B is there. He is being made to work 14 hours a day. Okay, 14 hours a day. So he will also feel tired. For 7 to 8 hours of working, he will feel tired. So one day what he will do, he will think of filing a case in the Supreme Court. He will go to Supreme Court and he will say, my factory owner is making me to work 14 hours a day. So I am really tired, I cannot work. But I cannot leave this work also, because if I go back, then I have to, I am the only breadwinner of the family. My family requires that I have to work. So when he files a case in the Supreme Court will study this law. So after studying the law, Supreme Court will see that section 50 says 15 hours a day. So already it is mentioned and they are making you to work 14 hours per day. So it means company is not violating the law. Okay, not violating the law. So company will say, we are not going to punish company X, so you have to work 14 hours per day. So why it is so? Because in India, it is procedure established by law. Whatever the law says, so Supreme Court and High Court will work according to it. Okay, according to it. Now when we say due process of law, as per the American Constitution, so it will not only challenge the law on the grounds of being unlawful, unreasonable. So as human beings, we know that maximum a person can work. Now forget about the UPSC aspirants. You all read about 15 hours per day. Okay, that's different thing. Because he will be sitting in a room and he will be reading. That's a different thing. But a person who is working in a factory, it's quite different. So I hope all of you read minimum 15 hours, right? Okay. So now a person who is working in a factory, for him more than 8 or 10 hours, it will be difficult for him. So when he challenges in the US Supreme Court, even if the law says that 15 hours per day, US Supreme Court will say this 15 hours per day is unreasonable. It is unreasonable. It has to be reduced to 8 hours. Okay. So that is called as due process of law. So when it comes to power of judicial review, so that's why we say the American Constitution, the American Supreme Court, the judicial review power is wider in USA as compared to India, because it follows what? Due process of law. Okay, due process of law. So just to make you understand, I have given this example. This example is not important, but they asked question on this. Again, I will show you the question as well. So it is, USA is due process of law. Indian Constitution, it says procedure established by law. Supreme Court examines only the substantive question, that is whether the law is within the powers of the authority concerned or not. It is not expected to go into the question of reasonableness, suitability or policy implications. So Supreme Court will not go into detailed aspects whether the law is correct or not, but they will check only whether the law is being followed properly or not, whether that law is as per the Constitution or not. Only that's it. Okay. The American principle of judicial supremacy. Okay. So in America, they have principle of judicial supremacy. Whether in India we have a principle of judicial supremacy? No. In India, neither parliament is supreme nor judiciary is supreme. So it's a synthesis. So America, we have a system of judicial supremacy. In India, it is recognized in our constitutional system, but to a limited extent. We too have judicial supremacy, but not to the extent that exists in USA, to a limited extent. So these things you have to memorize from exam point of view. So if they give you about 2 to 3 countries, and if they ask you which country has judicial supremacy, UK, India or USA? Okay, USA. British principle of parliament supremacy, we have discussed this. I think during the discussion of parliamentary system, we do not fully follow it. So we do not have complete parliamentary supremacy. Yes, you have seen, right? What are the limitations on the sovereignty of parliament? We have discussed these points under which topic? Parliamentary system. Okay. So written character of the Indian Constitution. So because of that, Parliament cannot make law as per its whims and fancies. Next, federalism with division of powers. So Parliament cannot make a law on the stateless subject. Fundamental rights. Parliament cannot make a law by taking away the fundamental rights. Next, judicial review. So all these are the things which impose restriction or limits on the sovereignty of the Parliament. So here in India, what exists is a synthesis of both. What is that? American principle of judicial supremacy to some extent, British principles of parliamentary supremacy to some extent. Not Parliament is neither completely supreme nor judiciary is completely supreme. So India is a synthesis of both. When it comes to parliamentary supremacy, it is Britain. When it comes to judicial supremacy, it is USA. So India is a synthesis of both. Synthesis of both. So next, other powers of Supreme Court. So we discussed about what? Exclusive original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory opinion, court of record. Next, judicial review. Okay, judicial review. Next, other powers. It decides disputes regarding election of president and vice president. Already we have seen while discussing the topic of president and vice president. Whenever there is a discrepancy with respect to the election of president and vice president, where the case will take? Supreme Court or High Court? Yes, Supreme Court. When it is election dispute related to election of members of Lok Sabha or Raj Sabha, High Court. Okay, High Court. Next, these disputes, original, exclusive and final. Election of president, election of vice president. So it is original, only Supreme Court can hear it. Exclusive, sorry, original means exclusive, only it can hear it. And original means first instance, and whatever the decision it gives, it is final. It cannot be challenged. Next, UPSC, chairman plus members. Again, we will be discussing a separate topic called as UPSC. So, inquire into conduct and behavior. References made by president. Okay. So, president will receive some kind of complaint saying that UPSC chairman or member is involved in fraudulent behavior. Okay, this is not true, but let's assume someone makes a complaint to president. So, now what president will do? Before taking an action, he will make a reference to Supreme Court. What he will tell to Supreme Court? I have received a complaint that chairman and members of UPSC, they are involved in some unwanted activities. So please study and report back to me. So Supreme Court will inquire into the matter and into conduct and behavior of members and chairman of UPSC. Now finally what they will do? They will give recommendations to president. So if they have committed mistake, then they will say, yes, they have committed mistake, remove them. If they are innocent, then they will say, they are innocent, don't do anything to them. So whatever the report the Supreme Court will give to president, if the Supreme Court says that, yes, they are guilty, they have to be punished, then what president will do? If found guilty, recommendation to president binding. If whatever the recommendation the Supreme Court gives to president, it will be binding on president. This is very important. In the previous cases, when references were made by when opinion was sought by president from the Supreme Court, whatever the opinion it gave, it was not binding. But in this case, after studying whatever the opinion the Supreme Court gives, it will be binding on president. It will be binding on president. Okay. Review its own judgment or order. So review its own judgment means previously one judgment has already been given. Can you take a different stand later on? For example, today we will say that yes, he has committed mistake. After few days he will say that no, I have gone through the documents once again, I have understood that he has not committed the mistake. So whatever the judgment you have given previously, that judgment can be changed. That is called as reviewing its own judgment. Whether Supreme Court can review its own judgment? Yes. Example, whatever the judgment it gave in Keshwanand Bharti case, it departed from its previous judgment of Golaknath case. Means whatever the judgment it had given in Golaknath case, so it changed that judgment and it gave a different judgment in Keshwanand Bharti case. From this we understood that what? Supreme Court can review its own judgment. So reviewing its own judgment is different from judicial review. Okay, judicial review. withdraw cases pending before High Court and dispose them by itself. So some cases which are present with the High Court, so even final judgment has not been given by High Court, but even when it is in the hearing stage itself, Supreme Court will take the case by itself and it will give a final judgment. So that power also Supreme Court has. Transfer a case or appeal pending before High Court to another High Court. So let's assume there is a case which is pending in Kerala High Court. This case can be transferred to Karnataka High Court. Transfer a case or appeal pending before High Court to another High Court. Its law is binding on all courts in India. Its decrees or orders enforceable throughout the country. All authorities in the country should aid in the Supreme Court. So Supreme Court, whatever the judgment it gives, so all should follow that judgment. Okay, all should follow the judgment. So all the authorities should help the Supreme Court in this matter. For example, the orders given by the Supreme Court, if anyone is not following properly, so for example, let's take police force. So it will make sure that people are following that order because that order has been given by Supreme Court. So again, you ignore this point. So just all the law made by Supreme Court is binding on all courts in India. Ultimate interpreter of the Constitution, we know it. Power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory. So apart from Supreme Court, we have many courts, high courts, tribunals, district court and all. So ultimate control on all these courts lie with the Supreme Court. Okay, Supreme Court. Supreme Court's jurisdiction and powers with respect to matters in the union list can be enlarged by Parliament. Okay. Now we have union list. So union list, how many subjects are there? 100. So let's assume 1 to 60 and 61 to 100. So initially let's assume Supreme Court can hear cases only related to these 60 matters. Now we want to make Supreme Court powerful to hear the cases related to these matters as well. So when you give more powers to the Supreme Court, that is called as enlargement of the jurisdiction. Who can do this enlargement? Parliament. Supreme Court's jurisdiction powers with respect to matters in the union list can be enlarged by Parliament. Supreme Court's jurisdiction powers with respect to other matters apart from the union list. Which are the other matters? State list and concurrent list. So such matters can be enlarged by a special agreement of the centre and the states. Exact procedure they are not given. So when it comes to union list, only Parliament can enlarge. When it comes to other matters, centre and states, they have to sit together and they should decide how much powers have to be given to Supreme Court. Okay, Supreme Court. Next, Supreme Court advocates. So who are advocates? Who practice in the court of law, especially Supreme Court. So Supreme Court advocates are those who are entitled to practice law before Supreme Court. So all people are not allowed to practice in front of Supreme Court. Only there are few people who have been identified as Supreme Court advocates, so they can practice in Supreme Court. So again, they have been classified into senior advocates and advocates on record. Senior advocates and advocates on record. So who gives this designation? Senior advocate is a designation given by either Supreme Court or any High Court for those deserving such distinction. So not everyone will be given an status of senior advocate. Only few will be given, and who is going to give this status? Supreme Court or High Court. Okay. Deserving such distinction. So what are the criteria required? They are not mentioned and hence not important. Okay. Are not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. So in Supreme Court, when a senior advocate goes for arguing, he cannot go alone. Along with him, there should be another person called as advocate on record. Okay. So in Supreme Court, whenever he is arguing, so senior advocate should be there. Along with him, compulsorily there should be an advocate on record. So who is advocate on record? We will not go into detailed aspects. Now, when senior advocate is appearing any other court, for example, High Court or District Court or any other court, so along with senior advocate, there should be a junior person as well, junior advocate. Okay, junior advocate, while hearing or while arguing for any other case in any other court or tribunal. So So not that an important information. Okay, you can just completely ignore it. Advocates on record, only they are entitled to file any material or documents before the Supreme Court. So in Supreme Court, when you are hearing a case, you have to submit some kind of documents and all. So that documents can be submitted by advocates on record. Senior advocate cannot submit the documents. Okay, cannot submit the documents. Other advocates. So advocates whose names are entered on the roll of any state bar council maintained under the Advocates Act 1961. So after completing the 4-year law graduation, law degree, so person will not automatically get entitled to practice in law. He has to register his name. So where? He has to register in a what? State bar council. So we have multiple bar councils. So here bar indicates what? Under the court's context. Okay. So we have state bar council, we have what? Supreme Court's bar council. We will be discussing about them later on. So once if a person wants to practice law, then he has to register his name. He has to register his name. So under which act? Advocates Act 1961. So whether it is State Bar Council or Central Bar Council, so it is administered by only one act, that is Advocates Act 1961. They can appear and argue any matter on behalf of a party in the Supreme Court, but they are not entitled to file any document or matter before the court. So here there is a bit confusion, so we will not go into deeper aspects. Okay. So they can appear and argue in any matter in any court, but they cannot file any document. Who can file the document? Advocates on record. Okay, advocates on record, not senior advocates. So we completed with the discussion of the Supreme Court. So first we started with the match the following, wherein we compared the provisions of Supreme Court and High Court simultaneously. Next we discussed some of the important Supreme Court provisions which we had missed while discussing with help of match the following kind of thing. So now we will be discussing about the High Court. Okay. So highest court of appeal in a state. So it is also a protector of fundamental rights of citizens like Supreme Court. Vested with the power to interpret Constitution. So whether it can interpret the Constitution, High Courts can also interpret the Constitution. But who is the highest interpreter of the Constitution? Supreme Court. Have a supervisory and consultative roles, which we will be discussing later on. Not that much important. Superficially you understand that. So whether High Court has a supervisory role? Yes. So where supervisory? Below the High Courts we have district courts and other courts. On them it has a supervisory role. Okay. And consultative roles not important from High Court. In case of Supreme Court is important, but here it is not that much important. You can just ignore it. So whether High Courts of India have jurisdiction over revenue matters related to taxes and all? Yes, they have. So even if you are not able to connect also, just understand from this fashion. Whether High Courts have jurisdiction over revenue matters? Yes. Pre-Constitution era, it was absent. It means before 1950, High Courts existed. In 1862 itself we have High Courts. But in those days, whether High Courts had the power of jurisdiction over revenue matters? No. After 1950, High Courts got power over the revenue matters. Over the revenue matters. Other additional powers conferred by the Constitution. Writ jurisdiction. We already discussed with respect to Supreme Court. Next we will discussing with respect to High Court. Power of superintendence, consultative power. So these are all generic nature. We will be discussing later on. Constitution has empowered both Parliament and state legislatures to change the jurisdiction and powers of High Court. So when we say change, whether we can give more powers? Yes. Can we curtail the powers? Yes. Yesterday we have seen even powers can be curtailed on matters mentioned in the Constitution or not mentioned in the Constitution. Not mentioned in the Constitution. So when it comes to Supreme Court, only powers can be enlarged. By whom? Parliament. By Parliament. Can they be curtailed? They cannot be curtailed. But in case of High Court, it can be changed. It means it can be either increased or it can be curtailed. Okay, it can be curtailed. So following jurisdiction and powers. Now here when it comes to examination, exam point of view is very important. Because there is so much of content we have to understand. When it comes to original jurisdiction and all, UPSC often focuses on Supreme Court and very rarely on High Court. So we have to prioritize the things. Okay, very important. We have to prioritize. So what is that? So original jurisdiction of Supreme Court is very important, but original jurisdiction of High Court is not that much important. Okay, not that much important. So original jurisdiction of High Court, it can hear marriage related to issues related to marriage as well as will. Okay, so directly Supreme Court can hear it. High Court can hear it. Next, election disputes of MPs and MLAs and MLCs. So whenever there is an election related dispute with respect to President and Vice President, it is Supreme Court. When it comes to MP, when it comes to MLAs and MLCs, it can be heard by High Court. So it means election disputes of MPs, it cannot be heard by District Court. It cannot be heard by District Court. Revenue matter, fundamental rights enforcement. Okay. It can transfer subordinate court to own file interpretation of the Constitution. So again, not important, just leave it. So when it comes to District Court or any other court, if they are not able to give a proper judgment because of the constitutional matters, it can take to itself. So what I will urge you, just ignore this point itself. Just ignore this point. Calcutta, Bombay, Madras and Delhi High Courts have original jurisdiction in case of higher value. Just ignore this also. Okay, just ignore this value. So already we have discussed about the writ jurisdiction of Supreme Court, and there we saw that the writ jurisdiction of Supreme Court is wider or High Court is wider? High Court is wider. So article number 226 deals with the writ jurisdiction of High Court for enforcement of fundamental rights and any other purpose. Okay. So can issue to any person, authority and government not only its territorial jurisdiction but also outside its territorial jurisdiction if the cause of action arises within its territorial jurisdiction. So here, okay, when it comes to High Court's writ jurisdiction, it can issue to a person not only who is present in that particular state. Let's assume Karnataka. It can also be issued to a person who is present outside state. For example, someone has committed a murder in Karnataka and he has gone to other state. Let's assume Tamil Nadu. So even a writ can be issued against him as well. Okay, him as well. Concurrent with the writ jurisdiction of Supreme Court. So both Supreme Court and High Court can issue writs with respect to the same matters. That is violation of fundamental rights. Article number 32 deals with the writ jurisdiction of Supreme Court. Article number 226 deals with the writ jurisdiction of High Court. So this point is important. Which one has a wider jurisdiction when it comes to writs? High Court has a wider jurisdiction when it comes to what? Fundamental rights or writs. Sorry, not fundamental rights. High Court's writ jurisdiction is wider than that of Supreme Court. So in Chandrakumar case 1997, Supreme Court ruled that it forms the part of the basic structure of the Constitution. So the writ jurisdiction of the High Court, it forms a basic structure of the Constitution. So it was declared in Chandrakumar case, not important from Plim's point of view. In Main's point of view, you can quote. But from Plim's point of view, maximum what they can ask is whether writ jurisdiction of High Court, it comes under the basic structure of the Constitution. Yes. So in which article do we have the term called as basic structure? No. So through which judgment we came across the term called as basic structure? Keshwanand Bharti case. Okay, Keshwanand Bharti case. So what we will do when it comes to High Court, that is appellate jurisdiction. Okay, we will not go through any of this content, and I will also urge you not to go through this. Okay, not important, because again here exams demand is very important. Supreme Court, it's an important body. We saw, even though it is not important also, we discussed about the appellate jurisdiction in detail. Now here we will not even discuss, and I will urge you not even to go through it. Unnecessarily it will lead to confusion. Okay, it will lead to confusion. So it can hear matters, it has appellate jurisdiction with respect to civil matters. So I will ignore all these points. So Bombay, Calcutta, Madras, all these things you will ignore. So if you think that you need to go through this content, when you will go through this content? When you have completed the entire syllabus of polity, geography, history, economics, science and technology, environment, art and culture, international relations, then you have a surplus time. Okay, probably in the month of May. When you have completed all the topics of all the subjects, then when you have surplus time, whichever you have skipped, you can go through this content. Until that point, you will just ignore it. Okay, you will ignore it. Because what happens once you start reading, you will start gaining interest. So this is what happens. Majority of the aspirants, when you ask them a favorite subject, their favorite subject will be polity. Okay, their favorite subject will be polity, because every time they read, they will be understanding few points based on the basic information which they have, and that keen interest which they will build in polity. So they will spend too much time on polity, ignoring other subjects. So that should not happen. So polity, okay, sometimes it will be 10 questions, sometimes 15, it's okay, but only using polity alone you cannot crack the prelims. So you need to be jack of all the other subjects as well. Hence you need to understand the prioritization, so which has to be given higher priority, which has to be accorded lower priority, and this cannot happen at the time of examination. From now itself that approach has to be built. Okay, that approach has to be built. So we will completely ignore this matter. This one point you just again in current affairs also will come. Tribunals, we will be discussing about different tribunals. Okay, tribunals are also something similar to courts itself, but in courts we have only judges, but in tribunals apart from judges we also have experts. For example, if we take National Green Tribunal as an example, so in National Green Tribunal apart from what judges, there will be people who are experts in environment related matters, so they are called as tribunals. So tribunals, division bench of the State High Court said that tribunal subject to writ jurisdiction of High Courts, no direct appeal to Supreme Court without going to High Court. So some tribunal will give a judgment. So there are two options for tribunal. Either it can be appealed in High Court, and if you are not satisfied with High Court, then you can go to Supreme Court. Okay. So in one judgment they have said that you cannot directly go to Supreme Court without going to High Court. But again, from current affairs point of view, it's not important. Why? Because in current affairs we'll see in some agencies directly you can file an appeal from a tribunal to a Supreme Court, and in some cases you have to file an appeal to High Court and then it will go to Supreme Court. So from that context, again, it should not cause confusion. You just leave this matter as well. So similarly here, you ignore all these things. Just retain the content that in case of civil criminal matters also, High Court can exercise what jurisdiction? Appellate jurisdiction. Okay, appellate jurisdiction. Supervisory jurisdiction of High Court. So power of intendance over all courts and tribunals functioning in its territorial jurisdiction, a broad power extends to all, whether they are subject to the appellate jurisdiction of High Court or not. Administrative superintendence plus judicial superintendence. Regional jurisdiction can be suo motu on its own. However, it does not vest with any unlimited authority, sparingly used in appropriate cases. So here on all these points, you just focus on this point. Administrative and judicial superintendence. Rest all the points, you just ignore it. So administrative superintendence means, so where the taluk court should be established, in which place, where the district court should be established, how many judges should be there, and to a particular court, district court, how much money we have to allot for tea, how much we have to allot for coffee. So these are all what administrative superintendence. Next, judicial superintendence, which judge should hear which case. Okay, so these are all what judicial superintendence. So when it comes to supervisory jurisdiction of High Court, it consists of both administrative superintendence as well as judicial superintendence. So all the other things we just ignore it. Okay, just ignore it. So it has control over all the courts and tribunals which lie within the state. Okay, within the territory of that state. Here one more is the suo motu. It comes also in other cases as well. So suo motu means on its own. So some cases, what it can do is, it can take on its own. Now generally how the cases are registered, someone will file a case in the court. Without a case being filed in the court, it will understand the situation and it will initiate a case by itself. That is called as suo motu. Okay, suo motu. So again, it does not mean that it has unlimited authority. Again, its authority is limited. Okay, again, not important. Here we will see few things, because again the things will be connected with subordinate courts. Once we discuss, once we start discussing about the subordinate courts, it will become important. In addition to appellate and supervisory jurisdiction, administrative control over them, so consulted by governor in the appointment of judges. Okay, so now how we will retain this content? Who is going to appoint the judges of the district court? We know Supreme Court, we know High Court. Who will appoint the judges of the district court? It is governor. Okay, so governor, while appointing the district judges, he will consult whom? He will consult the High Court. He will consult. In addition to appellate and supervisory jurisdiction, administrative consulted by governor. So governor will consult the High Court when he is appointing district judges. Okay, it may be appointment, or it may be promotion, or it may be posting. Okay, it may be posting. Next, judicial service of state appointments other than district judges. So other than district judges, let's assume taluk judges and all, then also governor when appointing, he will be consulting what? High Court. Okay, High Court. So matters of judicial service. So for example, posting, promotion for all the judges. So what High Court deals with it, not important, just leave it. Okay, so whatever we have seen in the Supreme Court, whatever the pending cases are there in the High Court, those cases can be taken by Supreme Court. Similarly here, whichever cases are pending in the district court, that can be taken by High Court and disposed by themselves. So not important, just leave it. So its law is binding on all subordinate courts, again not important. When we say higher authority Supreme Court, its law is binding on all the lower courts. Similarly, High Court is the highest court in a state. So whatever the judgment it will give, whatever the rules and regulations it will make, it will be binding on all the lower courts. Okay, lower courts. So this is very important. High Court as a court of record. Okay, so there we saw a Supreme Court as a court of record. So what were the various powers which the Supreme Court enjoyed as a court of record? Perpetual memory. Whatever the judgments the Supreme Court will give, so it will be in perpetual memory. Anyone can quote this judgment in any court of law. That is one. Next. Yes. So it can. There is a contempt of court. That also comes under court of record. Next. Power to review its own judgment. That also comes under court of record. Okay, court of record. Evidentiary value. Any subordinate court. Here also, when High Court gives a judgment, that judgment can be quoted in Supreme Court. Whatever the judgment Supreme Court gives, that judgment can be quoted in High Court or in District Court also. My question is, when a High Court gives a judgment, okay, that judgment can it be quoted in Supreme Court? No, it cannot be quoted in Supreme Court. It can be quoted in the lower court, like District Court and all. Okay. Punish contempt of court. So can Supreme Court punish for the contempt of court? Yes. Similarly, High Court can also punish for contempt of court. So simple imprisonment of fine, not important. We'll leave it. Okay. Not defined by the Constitution. This is very important. Whether the term contempt of court is defined in the Constitution, very important. It's not defined. Now we have seen various terms, right? Like judicial review. The term judicial review is not defined in the Constitution. Next, basic structure is not defined in the Constitution. Similarly, the term contempt of court is not defined in the Constitution. So what does it mean? They are not defined. So where do we find the definition of contempt of court? The term contempt of court is present, but it is not defined. Okay, it is not defined. So for example, okay, again we shall not get confused. The term judicial review is not present in the Constitution. Okay. The term office of profit is present in the Constitution? Yes, it is present. Whether it is defined? No. Similarly here, the term contempt of court is present in the Constitution, but it is not defined. So where do we find the definition of contempt of court? Contempt of Court Act 1971. Here we find the contempt. So previously we saw the definition of civil contempt and criminal contempt, right? So if a person does not obey the orders of the court, so what kind of contempt it is? Civil court or criminal contempt? Civil contempt. Okay. So if he criticizes the court's order through a newspaper article or a YouTube video, it will be criminal contempt. So those definitions are present in Contempt of Court Act of 1971. So fair criticism and publishing do not amount. So whenever when you are criticizing in a very fair manner, it should not be considered as what? Criticism. Again, it will lead to confusion. Just leave this point. Okay. So power to review and correct its own judgment or order or decision. So now it is not judicial review. Previously, whatever the judgment it has given, if it thinks that that judgment was not proper, can it correct the judgment? That is called as reviewing its own judgment. So can High Court do the same? Yes. So even though no specific power of review is conferred on it by the Constitution, so High Court, whatever the judgment it has given, it can change, it can reverse, it can review the judgment. But whether this provision is explicitly mentioned in the Constitution? No. Even though explicitly it has not been mentioned in the Constitution, but High Court enjoys the power to review its own judgment. Okay, power to review its own judgment. So even the Supreme Court and High Court, they enjoy the power of judicial review. Whether the term judicial review is explicitly mentioned in the Constitution? No. Similarly here, even though explicitly it has not been mentioned, okay, but still the High Court, what it does, it has the power to review its own judgment. Supreme Court, on the other hand, has been specifically conferred with the power to review by the Constitution. Very important. We are discussing about this very important point. Power to review its own judgment. Whether Supreme Court also has, whether High Court has, yes. So to Supreme Court, whether Constitution has been explicitly conferred, Constitution has explicitly conferred the power. Yes. Again, we will not go into detail like which article and all. Whether High Court has been explicitly conferred with this power? No. So both Supreme Court and High Court have the power to review its own judgment. Supreme Court has been explicitly given power by the Constitution, whereas High Court has not been given explicitly that power by the Constitution. So this is very important point. Now see here, this is different. High Court's power of judicial review. So now in the examination, if they ask you, so High Court's power to review its own judgment, so derives from which point? Court of record. From court of record, it has various provisions. One is contempt of court, another one is power to review its own judgment. Next, High Court's power of judicial review can examine constitutionality of legislative enactments and executive orders. You can compare it with that of the Supreme Court, both central as well as state government. So it has the power of judicial review with respect to both central laws as well as state laws, with respect to center's executive orders, with respect to states' executive orders. Term not present in the Constitution, judicial review, but provisions of article number 13 and 226 explicitly confer the power on the High Court. When you read article number 13 and 226, you will understand that High Court has the power of judicial review. So from exam point of view, if they ask, the judicial review power has been conferred on the High Court explicitly, true or false? Okay, the power of judicial review has been explicitly conferred on the High Court by the Constitution. Okay, it's true. The power to review its own judgment has been explicitly conferred on the High Court by the Constitution. False. The power of judicial review has been explicitly conferred on the Supreme Court by the Constitution. True. The power to review its own judgment has been explicitly conferred on the Supreme Court by the Constitution. Okay, so these things are very important. Constitutional validity of central laws, 42nd Amendment, 40 not important, just challenge grounds same as Supreme Court. Okay, so what are the grounds on which you can challenge legislative enactment or executive orders to High Court? Same as that of Supreme Court. So which are the grounds? Can you recall? Fundamental rights are violated when a center makes a law on the state list subject. So these are the same grounds which are discussed under Supreme Court. So clearly, I think we came to the end of the topic itself. So here I compiled this list to indicate the state and the corresponding High Court. Okay, again this list is important. So first, if they ask you a question, how many High Courts are there in India?
25.
Okay, so first we need to have that clarity. So we have 25 High Courts. First level of question, how many High Courts are there in India? 25. Okay, 25. So the name of the High Courts, Allahabad High Court, jurisdiction is Uttar Pradesh. Andhra Pradesh High Court, Andhra Pradesh. Okay. Next, Bombay High Court. So it has jurisdiction over so many areas: Maharashtra, Goa, Dadra and Nagar Haveli, and Daman and Diu. Now they have been united. Okay. So next, Calcutta High Court, West Bengal, Andaman and Nicobar Islands. Chhattisgarh. Name of the court is also Chhattisgarh High Court. Jurisdiction also Chhattisgarh High Court. Delhi, Guwahati, Assam, Nagaland, Mizoram, Arunachal Pradesh. Okay, 4 states. Gujarat, Himachal Pradesh, Jammu and Kashmir and Ladakh. Jharkhand, Karnataka, Kerala High Court, Kerala and Lakshadweep. Madhya Pradesh, Madras, Tamil Nadu and Puducherry. Manipur has its own High Court. Meghalaya has its own High Court. Odisha has its own High Court. So Bihar, we call this Patna High Court. Next, Punjab and Haryana. So there is a common, we call this Punjab and Haryana High Court, which is common for Punjab, Haryana and Union Territory of Chandigarh. So Rajasthan High Court. Sikkim has its own High Court. Telangana, so recently created, Telangana has its own High Court. Next, Tripura High Court. Uttarakhand High Court. There are 24 High Courts in India. 25. So year not important except oldest. So here in the exam, in the book, what they have mentioned is they have given the year of formation of each and every High Court. That year of formation is not important. Just out of curiosity, oldest. So which is the oldest High Court among these? Madras, Calcutta Bombay. Only we'll focus on these things. Okay, oldest high courts. Seats not important. So some high courts, for example, if you look at Karnataka High Court, so apart from Bangalore, a seat is also established at Dharwad. So those things are not important. Hence, I have not mentioned them. Seats not important. So out of curiosity, I have added high courts with jurisdiction over more than one state. More than one state. So Punjab and Haryana High Court. So which are they? Punjab, Haryana and Chandigarh. Guwahati High Court. Arunachal Pradesh, Nagaland, Mizoram is there. Next, only 3. 4. Which are they? Assam, Arunachal Pradesh, Nagaland, Mizoram. Next, Bombay High Court. Alright, Nagar Haveli. Okay. So high courts with jurisdiction over more than one state or union territory. So again, the same list. So these are the 7 such high courts. So Punjab and Haryana High Court we saw, Guwahati High Court, Bombay High Court, Madras High Court, Jammu and Kashmir High Court, Kerala High Court. So which is the other jurisdiction of Kerala High Court? Lakshadweep. West Bengal, Andaman and Nicobar Islands. Okay. So with this we have concluded with the topics, 2 topics. One is Supreme Court and the other one is High Court. Okay, High Court. So wherever I mentioned that ignore those points. So I'll urge you to ignore for a time being. Otherwise, again, you'll be stuck there itself. You will not be able to make progress to the next topic. Okay, next topic. So with this, we shall conclude the topics called as Supreme Court and High Court.